为粤语，频道4为俄语。线上的参与者可于网页页面上选择语言的頻道。我們建議你使用耳機，這樣收聽的效果會更好。今日嘅高峰會將以英語進行，並提供外語、普通話及粵語嘅即時傳譯。如果需要耳機，請到入口服務台領取。請注意，頻道1為英語，頻道2為普通話，頻道3為粵語，而頻道4為外語。線上參與者可以喺網頁畫面上面選擇語言頻道。我哋建議大家使用耳機，咁樣嘅收聽效果會更加好。For participants who would like to apply for the CPD points and ALE points, please sign in and sign out at the reception counter. Thank you for your cooperation. Please be reminded, only in-person participants will be eligible for CPD points and ALE points. Please note, on the screen, you will find the QR code to access today's program. Thank you very much. Good morning, honorable judges, distinguished guests, ladies and gentlemen. Thank you for joining the 6th UNCITRAL Asia Pacific Judicial Summit 2025, co-organized by the United Nations Commission on International Trade Law, UNCITRAL, the Hong Kong International Legal Tenants Training Academy of the Department of Justice of the Hong Kong Special Administrative Region of the People's Republic of China. I'm Melody, your MC for today. Before we begin our program, I would like to invite everyone to join me in observing a moment of silence. Last week, a devastating fire broke out in Tai Po district of Hong Kong, which claimed many lives and left many injured. Let us take a moment to remember those who lost their lives, those that are still recovering, those missing, and all those families and individuals that are affected by this tragedy. In order to maintain a solemn atmosphere to show our respect to them, please refrain from giving applause or clapping hands during the conference today. May I now invite everyone to please stand up to observe 1 minute of silence. Thank you. Everyone, please be seated. The theme of the Judicial Summit 2025 is "The Future is Now, Legally Enabling Digitalization of International Trade." In the Judicial Conference today, we will focus on building towards end-to-end digitalization. To kick off the Judicial Summit, may I invite the Honorable Mr. Paul Lambton Kwok, GBS SC JP, Secretary for Justice of the Government of Hong Kong's Special Administrative Region, People's Republic of China, to deliver the open remarks. Please. Mr. Lam.
The Honorable Chief Justice, Mr. Andrew Zhang, Ms. Anna Cherubin-Brett, Professor Teresa Zhang, Your Excellency, Consul General, distinguished guests, ladies and gentlemen. As we gather today for the 6th UNCITRAL Asia-Pacific Judicial Summit, we also kickstart the Hong Kong Legal Week 2025. The Hong Kong Legal Week is an annual major event of the Department of Justice, which serves as a dynamic platform for the legal and dispute resolution sector, legal scholars, judges, and experts to discuss key topical legal issues in the Asia-Pacific region and beyond. Under the theme of Linking Laws, Bridging Worlds, Hong Kong Legal Week 2025 aimed at highlighting Hong Kong's role in connecting different economies and legal systems through collaboration, understanding, and global legal exchange. Under the fundamental principle of one country, two systems, Hong Kong is the only common law jurisdiction in China. With our strong legal foundation and international connectivity, Hong Kong is dedicated to serve as a super connector and capacity building hub in order to facilitate the legal and economic collaboration across the region and beyond. The 6th UNCITRAL Asia-Pacific Judicial Summit is co-organized by the UNCITRAL and Hong Kong International Legal Talents Training Academy of the Department of Justice under the theme, "The Future is Now, Legally Enabling Digitalization of International Trade." Today, we have more than 50 judges from over 25 jurisdictions attending in person, with numerous other jurisdictions joining virtually, including those from ASEAN, Central Asia, and Pacific Islands, reflecting the global reach and importance of the summit. To facilitate the participation of Russian-speaking judges from Central Asia, we are grateful to the support given by the Asian Development Bank, the ADB, for providing simultaneous interpretation from English into Russian. In fact, this is not the first time we've worked with ADB and UNCITRAL on capacity building. This Judicial Summit actually marked the third event that we have co-organized with UNCITRAL this year. Since the Department of Justice launched the Hong Kong International Legal Training Academy during the Hong Kong Legal Week last year, the Academy and UNCITRAL have co-organized capacity building programs, including the Conference on Climate Change and International Trade Law just marched in Hong Kong, and a workshop on use of international instruments to legally enable end-to-end digitalization of trade under Economic Committee of APEC in Incheon, Korea in August this year. This collaboration have not only contributed to capacity building for stakeholders in the region, but also the further development of international trade law. In addition to co-organizing events with UNCITRAL, we work with UNCITRAL to set up the inclusive global legal innovative platform on online dispute resolution, in short, the ICLIP on ODR, and which will hold its 5th expert meeting tomorrow to discuss international development and potential issues relating to ODR. Besides, we are delighted to see UNCITRAL's strong support for the secondment program with the Department of Justice, which enable Hong Kong legal practitioners to actively take part in UNCITRAL's work and enhance their knowledge of international legal matters, thereby contributing to the capacity building of our local legal practitioners as well. And I note that a number of our colleagues who have been seconded to UNCITRAL Regional Center for Asia and the Pacific are also with us today. Apart from the objective of capacity building, the Judicial Conference, which centers on the theme Building Trust End-to-End Trade Digitalization, provide a platform to share experience and exchange views on critical issues and facilitating digitalization of the entire trade process, digitalization of trade finance and digital assets, paperless trade system, digital transformation and transport, as well as emerging trends in dispute resolution within the rapidly evolving digital economy, with reference to the application of UNCITRAL tax. In fact, UNCITRAL tax have been proven to be a very useful tool for creating a harmonized and enabling legal environment. We have applied and implemented quite a number of UNCITRAL tax ranging from conventions to model laws in various areas. Very soon, as announced in the Chief Executive Hong Kong Policy Address this year, Hong Kong would introduce legislative amendment in 2026 for digitalization of business-to-business trade documents with reference to the model law on electronic transferable records adopted by UNCITRAL. Complementing the Judicial Conference today, the Judicial Roundtable to be held tomorrow will explore recent trends in dispute resolution in order to facilitate interactive and in-depth dialogues among judges and judicial office in the region on innovative judicial approaches for handling dispute involving artificial intelligence, as well as the dynamic interaction between alternative dispute resolution mechanisms and formal court proceedings. Let us seize the opportunity to actively engage in exchanges, whether in person or online. Before I conclude, may I express my appreciation to UNCITRAL again for their partnership, the Asian Development Bank for the support, and my heartfelt gratitude to all the moderators and speakers. Some of them have come from afar, as well as the Secretary General of the International Organization of Mediation and our Chief Justice, who will give special remarks and a keynote speech in a moment. And on this note, I announce the official opening of the Hong Kong Legal Week 2025. Thank you.
Thank you, Mr. Lam. Please be seated. May we now invite Ms. Anna Jubin-Brett, Secretary of UNCITRAL, to board the stage to deliver the welcome remarks. Ms. Jubin-Brett, please. Thank you.
Secretary for Justice, the Honorable Paul Lam SC, the Honorable Chief Justice Andrew Chong, Deputy Director General Mr. Tian Ya, Department of Treaty and Law, Ministry of Commerce, China, Professor Teresa Cheng SC, Secretary General of the International Organization for Mediation, Honorable Justices, distinguished speakers, and guests. I would first like to express our heartfelt condolences to everyone affected by the devastating fire in Hong Kong last week. Our thoughts are with the victims, their families, and all those impacted by this tragedy. We also pay tribute to the bravery of the first responders, especially the fire officer who gave his life in service, and we stand in solidarity with the people of Hong Kong, China, during this difficult time. Today marks the opening of the 6th UNCITRAL Asia-Pacific Judicial Summit 2025, a biennial flagship event jointly organized by the UNCITRAL Regional Center for Asia and the Pacific and the Department of Justice of Hong Kong, China. Many thanks to our friends and partners at DOJ for bringing together judges, officials, academics, and legal experts from almost 40 jurisdictions globally and in Asia and the Pacific region, ranging from Armenia in the west on one end to Fiji and the Cook Islands in the east on the other, including from 9 least developed countries, landlocked developing countries, and small island developing states, thereby helping the UN be as inclusive as possible. UNCITRAL is grateful for Hong Kong, China's active contribution to the work of UNCITRAL. In addition to DOJ's annual provision of secondees to RCAB, for which we are immensely grateful. This year's collaboration are particularly impactful with 3 flagships organized, as Mr. Paul Lam has reminded us, with the UNCITRAL Regional Center for Asia and the Pacific, starting with the Conference on Climate Change and International Trade Law in March, the UNCITRAL APEC Korea Workshop on end-to-end digitalization of trade in August, and now this summit. UNCITRAL highly appreciates that the summit is being delivered in 3 of the 6 United Nations official languages. A special thanks to the Asian Development Bank for facilitating Russian interpretation, the working or common language of at least 8 of the jurisdictions present at this summit. My thanks also go to the expert speakers contributing insights from across the world at this critical and crucial juncture for international trade and for the United Nations. We count on your support more than ever. This year's summit showcases the full breadth of UNCITRAL's work on end-to-end trade digitalization, and I'm very pleased that the Secretariat is able to participate in full force. As all aspects of trade are now being digitalized, the importance of developing a dynamic, harmonized cross-border legal framework cannot be overstated. The certainty afforded by global standards is universally enjoyed by jurisdictions large and small, and decreases the risk and the transactional costs associated with doing business, especially for MSMEs, which account for 97% of all businesses across the Asia-Pacific region, and let us be reminded that this is the case in all countries in the world. Digital and financial inclusion is especially important. It's driving job creation and economic resilience. And the first panel, moderated by my colleague Monica Canafolia, will delve into how UNCITRAL instruments enable the digitalization of trade finance and how digital assets could serve as collateral and payment mechanisms in cross-border transactions. Digitalizing trade finance requires the recognition and the use of digitalized commercial documents. And panel 2 will showcase how the UNCITRAL model law on electronic transferable records, known in the region as MELITA, legally enables this across the board. The head of UNCITRAL RCAB, Atita Kominder, will navigate experiences and discussions on the MELITR foundational elements, implementing and building on the experience from early adopters and issues for consideration from the judicial perspective. As MELITA is attracting remarkable interest across Asia and the Pacific region, I look forward to hearing about ongoing consideration in Australia and China, including Hong Kong SAR. The draft United Nations Convention on Negotiable Cargo document that was finalized by the Commission in July and is set to be adopted by the General Assembly this month, maybe as we speak, will complement UNCITRAL's efforts to support the digital transformation of global trade. Legal Officer Yanying Li will remotely join panel 3 to discuss how this draft, I hesitate to say draft actually, this convention establishes NCDs as new negotiable documents of title, representing goods in transit across all modes of transport, land, sea, air, and rail. Until now, only maritime transport of goods has benefited from a widely recognized negotiable document. This levels the playing field, giving smaller or landlocked countries the means to integrate into global supply chains more effectively. Together with the MLETR, the draft NCD Convention can support the shift to paperless trade, and along with the UNCITRAL model law on the use of cross-border recognition of identity management and trust services, and the model law on automated contracting, this NCD Convention can standardize and advance digital transactions both within and across borders. The final panel will explore current trends in dispute resolution in the digital economy. In the words of the United Nations Secretary General, artificial intelligence is not just reshaping our world, it's revolutionizing it. Legal officer Judith Knieper will steer discussions on how technology, including AI, is enhancing access to justice, focusing on the use of artificial intelligence in dispute resolution, platform-based mechanisms, and procedural guidance on remote hearings and online mediation. UNCITRAL is also working on other legal challenges and issues arising from the digital transformation of trade, with the Commission authorizing this July the publication of a guidance document on legal issues relating to the use of distributed ledger technology, the famous blockchain, in trade, which assists businesses in assessing legal matters that may arise when procuring blockchain services or delivering services using the blockchain. In addition, the Commission requested the Secretariat to work on the default rules for data provision contracts, which is the ongoing work of our Working Group 4, on decentralized autonomous organization in trade, digital platforms, and private law, and digital payments. Ladies and gentlemen, honorable justices, esteemed participants, as we look ahead, UNCITRAL will, we hope, continue to shape the end-to-end digitalization of trade. The leadership of the Asia-Pacific region is critical, and I very much look forward to discussions over the course of this Judicial Summit on how we could work together to strengthen the legally enabling environment for international trade in the region and beyond. Thank you again to our co-hosts, the Department of Justice of Hong Kong, China, and to all of you for your attention. My best wishes for a successful summit. Thank you very much.
Thank you, Ms. Jovenret. Please be seated. Thank you. May we now invite Mr. Tian Ya, Deputy Director General, Department of Treaty and Law, Ministry of Commerce of People's Republic of China, to board the stage to give the welcome remarks. Mr. Stan will give his speech remotely. Everyone, please.
尊敬的林定国司长，尊敬的安娜秘书长，郑若华教授。
Honorable Secretary for Justice, Mr. Paul Lam, Honorable Secretary, Ms. Anna Zhou-Bing-Puhat, Professor Teresa Chang, Chief Justice Andrew Chang, ladies and gentlemen, good morning. It's a great honor to be invited to participate via video in the 6th UNCITRAL Asia-Pacific Judicial Summit, co-organized by the Hong Kong International Legal Talent Training Academy Department of Justice. And first of all, please allow me to express my gratitude to the organizers for their kind invitation and extend my sincere greetings and a warm welcome to all the distinguished guests present. Currently, digital trade is developing rapidly. The new round of a technological revolution and industrial transformation is developing in depth. With active innovation in digital technology such as internet, big data, cloud computing, AI, and the blockchain, the dividends of development are continuously being released, triggering profound transformation in global industrial chain, supply chain, value chain. Give a new meaning to this wave of economic globalization, and we have to be aware of different threats and challenges. In this regard, UNCITRAL has done fruitful work. Its legislative outcomes have effectively promoted the harmonization of e-commerce rules across countries, helping trading parties build mutual trust and reduce costs and improve efficiency, thereby providing legal safeguards. And this summit features sessions on digital trade, finance, and digital assets, paperless trade, digital transformation, etc. And these topics are both substantial and practical, facilitating exchanges and broadening of perspectives. Ladies and gentlemen, the proposal for the 15th five-year plan adopted at the 4th plenary session of the 20th Central Committee of the Communist Party of China calls for innovating and developing digital trade and expanding the opening up of the digital sector in an orderly manner. It also emphasizes enhancing the functions of trade promotion platforms and supporting new business forms and models, such as cross-border e-commerce. Encouraged and promoted by the Chinese government, the China digital industry has developed rapidly. For example, the black-maid Wukong, as well as AI products like DeepSeek, have also made remarkable appearance, attracting global attention. Alongside, the Chinese government has placed a great emphasis on advancing the construction of a legal framework for digital governance. And in addition, we also have aligned with the high standard international economic and trade rules. And the newly revised maritime law in October 2025 added a dedicated section on electronic transport records, incorporating the core content of ancestral model role on electronic transferable records, thereby providing legal assurance for the digitalization of bills of lading. At the international level, China has actively participated in UNCITRAL work on creating commercial rules in areas such as e-commerce. At China's proposal, the United Nations Convention on the International Effects on Judicial Sales of Ships, also known as the Beijing Convention, was concluded in 2022. And this convention confers international effect to clean titles of ships acquired through judicial sales, filling a long-standing gap. Recently, the UN Convention on Negotiable Cargo, actively promoted by China, has been adopted by the 6th Committee of the UN. And this convention aims to address the issue of ownership of documentation for various transport documents. It can help reduce financing costs and risks in land-based trade, improve transaction. Ladies and gentlemen, China will always uphold the vision of a community with a shared future of mankind, continue to firmly support true multilateralism and free trade, promote the implementation of the global governance initiative in the field of international commerce. To this end, we will always support UNCITRAL in playing a pivotal role in the formulation of international commercial rules. We will work hard, hand in hand with all parties, to continue contributing wisdom to improve the international legal framework for global digital trade. Finally, I wish the summit a great success. Thank you.
Thank you, Mr. Tian. Everyone, for the programs today, you will find the QR code to access to the Hong Kong Legal Week website, which also has the biographies of our speakers. May we now invite Professor Teresa Chang, GBM, GBS, SCJP, Secretary General of International Organization for Mediation, to deliver the special remarks. Professor Chang, please.
Honorable Chief Justice Andrew Cheung, Secretary for Justice Paul Lam, Secretary of UNCITRAL Anna Jobenbred, Deputy Director General Mr. Tian Ya, distinguished guests, ladies and gentlemen. Before proceeding with my remarks, may I express our heartfelt condolences to the victims of the disastrous fire in Taipo last week. We wish them peace during these difficult times. It is an honor and privilege to deliver the special remarks on behalf of the International Organization for Mediation at this UNCITRAL Asia-Pacific Judicial Summit, I wish to thank the hosts for affording us this opportunity. The International Organization for Mediation, or IOMED, is the world's first treaty-based intergovernmental organization dedicated exclusively to promoting the use of mediation in settling international disputes. In around 2020, 19 like-minded states gathered together and conducted several rounds of friendly consultation and negotiations. These exchange of views and dialogue ultimately led to the joint statement on the future establishment of the International Organization for Mediation, promulgated in 2022. The joint statement sets down the common goal of jointly initiating the establishment of the IOMED. The strategic vision of these states are highly commendable. They foresaw the need of a treaty-based international body to provide dedicated mediation services as an alternative to the global community to peacefully settle their differences. The preparatory office was established in February 2023 and located in Hong Kong. In 2023 and 2024, through an inclusive, consensus-based multilateral process, the Convention on the Establishment of the International Organization for Mediation was negotiated and eventually concluded. On 30th May this year, the signing ceremony of the IOMED Convention was held here in Hong Kong. The convention entered into force on the 29th of August. Then, in just under 5 months from the time when the convention was opened for signature, on the 20th of October, IOMED was inaugurated after the first session of the Governing Council meeting. As at to date, 38 states have signed the IOMED Convention, of which 10 have ratified it. With the consensus of the states, the headquarters of the IOMED is hosted in China. Our headquarters is located in a beautiful heritage building in Hong Kong, SAR. And on behalf of our member states, I would like to express our gratitude to the support of the Hong Kong government. This short span of time through which IOMED traveled from conceptualization to inauguration is significant. This fact and the increasing number of signatory and ratifying states manifest the strong desire of the international community, especially Global South, for mediation to be seriously considered and used as a viable alternative to settle international disputes. It also unequivocally shows the dedication and determination of all signatory states to pursuing the respectable cause of providing a global public good for peaceful settlement of international disputes. At this point, it is also very important to remember the other important developments in mediation internationally. It is right to pay tribute to the work of UNCITRAL over the years in championing mediation. In particular, the Singapore Convention on Mediation that was adopted in 2018 and entered into force in 2020, the UNCITRAL model provisions on mediation for international investment disputes, and the UNCITRAL guidelines on mediation for international investment disputes that were finalized and adopted in 2023 have all lent strength, confidence, and inspiration to passionate advocates of mediation like me. Together with other instruments in the international arena, they have also provided a credible basis and constituted important references for the development of the instruments of the IOMED, such as the mediation rules for international investment and international commercial disputes. The IOMED is a young international organization, only a month and 11 days old. Yet it is actually committed to a time-honored method of dispute resolution. Article 33 of the UN Charter identified mediation as one of the first means of peaceful settlement of disputes. However, for the past 8 decades, mediation has been underused. Whilst treaty-based bodies have been set up to provide mainly litigation and arbitration services, none have been established exclusively for mediation. IOMED is set up to fill this long-existing institutional gap in the overall landscape of international dispute settlement. It aims to stand alongside other treaty-based international bodies like the ICJ, PCA, and ICSID. Harnessing the unique strengths of mediation, IOMED will complement, not replace nor undermine the indispensable services of these international dispute resolution bodies. With its inauguration, we hope IOMED will enable mediation to gain stronger traction globally. The vision and mission of IOMED is to provide mediation services, promote mediation, and provide capacity building, and ultimately to contribute to the international rule of law. The IOMED provides mediation as a viable, efficient, and effective alternative for disputants in 3 types of international disputes: state-to-state disputes, international investment disputes, and international commercial disputes. There are 2 panels of mediators, the panel for state-to-state mediation and the general panel for international investment and commercial mediation. At the risk of stating the obvious, allow me to capture the main advantages of mediation. Mediation is truly voluntary by nature. It allows disputing parties to have full control of the process and outcomes rather than a binding decision imposed on them. As a result, mediated agreements have a high rate of compliance, and thanks to the Singapore Convention and the future protocol to be established under the IOMED Convention, the settlement agreements can also be enforced. Mediation is flexible. Disputants and mediators can think outside the box for a compromise solution rather than being confined by jurisdictional limits. Mediation is conciliatory, enabling the disputants to explore a way out for a win-win solution and thereby preserving the hard-earned relationships. Capacity building is an important part of our work. There are 2 aspects, one of raising awareness and knowing how to use mediation as a party, and the other training mediators. We will explore collaboration with international partners to provide tailor-made training for states and enterprises alike. Through these efforts, the IOMED aims to create a sustainable mediation ecosystem with a strategic vision. Ladies and gentlemen, allow me to applaud the theme, Linking Laws, Bridging Worlds, of this Hong Kong Legal Week. In a world fraught with risks of division and fragmentation, it is both timely and relevant. As a global public good, IOMED is also committed to fostering links and building bridges. Our strength lies in our diverse membership, 38 countries spanning continents, each bringing distinct legal traditions, cultural perspectives, and practical experiences. Our culture is rooted in inclusivity, from the consensus-based approach that created the convention to our open approach to partnership globally. We honor every voice and find common ground rather than deepening rifts. Our core is an unwavering commitment to multilateralism. We serve as a bridge, bridging impasse and opportunities through mediation, and to join hands to build a global public good. And last but not the least, may I wish this Judicial Summit every success. Thank you very much.
Thank you, Professor Chang. Please be seated. Next, we are privileged to invite the Honorable Mr. Andrew Chan Kwai-Nun, GBM, the Chief Justice of the Court of Final Appeal of the Hong Kong Special Administrative Region of the People's Republic of China, to board the stage for the keynote speech. Chief Justice Chang. please.
Secretary for Justice, Secretary Jobin Brett, Deputy Director General Tian, Secretary General Professor Chang, distinguished speakers, honored guests, ladies and gentlemen. It is a great privilege to speak to you at this conference on end-to-end digitalization. I would like to begin by expressing my gratitude to the organizers in hosting this 6th UNCITRAL Asia-Pacific Judicial Summit, which is the inaugural event of Hong Kong Legal Week 2025. Each year, we reaffirm our commitment to the rule of law through a series of enriching events during Hong Kong Legal Week. And this year is made even more special by the inclusion of this summit in the Legal Week program. Organizing and hosting events of this size and scale is no easy task, and as always, the organizers have acquitted themselves admirably. The work of UNCITRAL, of course, needs no introduction. Over the past 6 decades, UNCITRAL has played a critical role in the harmonization of international trade law through its creation and maintenance of both legislative and non-legislative instruments in key areas of commercial law. By adopting and utilizing these instruments, different jurisdictions enable trade law to develop in a common and mutually beneficial direction. To advance the efficiency of international trade, UNCITRAL has now undertaken work in the area of digital trade law. This includes reviewing developments in digital dispute resolution, compiling UNCITRAL material on electronic commerce, and examining innovations in the digitalization of trade, the use of digital platforms and digital payments. Most significantly, they are updating UNCITRAL's model laws on public procurement and secured transactions to facilitate end-to-end digitalization. It is therefore a great privilege to be invited to speak to you at this conference on end-to-end digitalization of trade. Obviously, I do not do so as a technologist or a policymaker, but as a judge. My observations come from the courtroom, where commercial documents are examined, where the rights and obligations they create are considered, and where remedies are sought. It is the place where the private world of commerce meets the public administration of justice. What I would like to offer this morning are some reflections on how courts are approaching the digitalization of trade and on the conditions that helped that process to function reasonably well in practice. Much of this will be familiar. My aim is simply to bring together some themes that have become apparent in recent years. It is often said that the law must keep up with technology, and there is certainly truth in that. The common law system we use in Hong Kong is well known for being flexible and adaptable. In fact, many aspects of commercial law are already highly flexible and able to adjust quite easily to new developments. Concepts such as consent, possession, control, good faith, notice, and risk allocation have been long established. They are not limited to traditional paper formats. They can also function within digital systems, provided those systems align with legal principles. The medium may change, but the fundamental legal concepts do not necessarily have to. When courts encounter disputes in digital trading systems, several key questions tend to arise. First, is the legal framework sufficiently clear? Can a digital record fulfill the same role as its paper counterpart? Second, can we reliably establish the sequence of events, such as who possessed what, when, and by what action? And finally, will any court order that is issued be both comprehensible and capable of being acted upon by those to whom it is directed. Where these conditions are met, courts can generally resolve such disputes using existing principles. In that sense, the law can be seen as applying familiar tools to newer forms. For this to work smoothly, it helps to remain anchored in the rule of law. By that, I mean that decisions, whether public or private, are made according to rules known in advance, applied in an even-handed way, with reasons that can be explained, and with access to an independent court if things go wrong. Digitalization can operate within that framework. Without it, systems can become difficult to understand and confidence may diminish. Many jurisdictions, including ours, have passed laws that recognize electronic trade documents as legally valid, just like paper documents. Indeed, in Hong Kong, the Electronic Transactions Ordinance was enacted as early as the year 2000. As the Secretary for Justice mentioned this morning, further laws are due to be enacted in Hong Kong next year. The role of the courts is to interpret and apply these laws in a sensible and consistent manner. In practice, the court looks for a single authoritative version of the record. There should be clarity as to who has control, and control should be capable of transfer. The integrity of the data matters. Roles should be clear. Who issued the document, who holds it, and who has received it. If these elements are present, digital instruments can usually be treated as valid. If they are not, the difficulties resembled those seen with defective paper. On evidence, what used to involve ink and stamps now involves digital signatures, audit logs, and timestamps. The standards are similar. The court needs to be satisfied that records are authentic, reliable, and complete. Judges do not need to be experts in coding or system architecture. It is, however, helpful if digital systems can produce a clear, readable account of what occurred, and if a responsible person can explain that account in a way that is easy to understand and withstands scrutiny. That tends to support confidence. Timeliness is often important in commercial matters, not only because business people are busy, but because trade often moves quickly. In litigation, delay can reduce the value of a remedy. Interim measures are therefore sometimes required to preserve the position while issues are being resolved. In a paper context, this might involve restraining delivery under a bill of lading. In a digital context, it may involve freezing the status shown on a platform, requiring disclosure of who has control, or suspending a transfer pending a hearing. Whether this is feasible depends on jurisdiction, on whether the relevant systems are contractually obliged to act on court orders, and on practical capability. Where these conditions are satisfied, the court can usually act without undue delay. International trade often spans multiple jurisdictions. Buyers, sellers, carriers, platforms, and goods may be in different places, and servers elsewhere. This is not new. Party autonomy remains important. Where parties make clear choices about the governing law and the forum, whether that be a court or an arbitral tribunal, those choices are, in general, respected. Beyond that, existing mechanisms for recognizing judgments and awards are utilized. In situations where the parties' choices are unclear, general principles of private international law come into play. The emphasis is usually on the obligations undertaken and the reliance placed on them, rather than merely on where the hardware is located. Control of a digital record can perform the function that possession of a paper document once did, and the law can accommodate this. Digital systems, like paper systems, are not immune to fraud or error. They can reduce some risk and introduce others. They may make tampering more detectable and can be designed to prevent duplication of title. If validation is weak, however, errors can spread more quickly. If the question of legal responsibility arises, the issues that would concern a court are familiar ones. What was reasonably foreseeable? What precautions were taken? And how did parties respond when problems emerged? Courts do not seek to penalize honest mistakes in well-managed systems. However, a stricter view is taken where basic controls are lacking, particularly where significant rights can be affected quickly. Measures such as segregation of roles, due authorization for sensitive actions, and alerts for unusual activity are sensible and practical. An increasing part of trade now involves public or quasi-public digital platforms. For example, customs declarations, certifications, and sanctions screening. These can improve efficiency. They should also allow for explanation and, where appropriate, for challenge. Where automated decisions affect rights, it should be possible to understand the basis of those decisions. Courts do not design such systems, but when those decisions are challenged, the court will ask whether statutory requirements were followed, whether reasons are intelligible, and whether the affected person had a fair opportunity to respond. These are, in fact, familiar questions, whatever the mode of decision-making. Arbitration continues to be central to international commerce, and courts support it. In Hong Kong, a highly pro-arbitration approach is adopted. The courts stay proceedings where arbitration has been agreed, grant interim measures where appropriate, and enforce awards. The presence of digital instruments does not affect this position. Occasionally, platforms not party to the dispute may need to assist, for example, by preserving a status or providing information. In those instances, orders that parties seek should be framed clearly and practically. The system functions best when each institution, court, arbitral tribunal, or platform performs its role and avoids overreach. Now, those who design and operate digital trade systems can assist the courts by considering a few points. First, the legal foundation. Where legislation governs electronic documents, comply with it. Where the law is still developing, use contracts to set out the legal status of records and how control is defined and transferred. Second, the evidence. It is imperative that the system can produce a clear and coherent account of events, and that a suitably qualified person can explain it. Third, remedies. It is always advisable to include mechanisms to give effect to lawful orders without unnecessary delay, maintain clear points of contact, and define who is authorized to act. Fourth, resilience. A good design plans for failure, maintains fallback mechanisms, considers escrow arrangements, and ensures there is a way to regain control after an outage. And finally, rights. Respecting confidentiality, privacy, and third-party interests is of paramount importance. This tends to reduce disputes and helps ensure that any orders made are uncontroversial. But courts also play a vital role. The business world expects the courts to apply laws consistently, to interpret established principles in light of new situations without unnecessary changes or unwarranted innovations. There's also a demand for procedures that can accommodate urgent matters. Additionally, at least commercial judges should be sufficiently knowledgeable about digital instruments to issue effective orders without excessive formality. These expectations are entirely reasonable. To this, one might add that where the law is unclear or incomplete, it may be better for the court to say so plainly so that legislative amendment may be considered, rather than to create new doctrine prematurely. The hardware of the justice systems matters too. A system in which both judges and lawyers continue to rely heavily on paper is in truth ill-suited to resolving disputes arising from digitized trade. The very notion that digital trade documents and records must be printed out in order for a case to be heard in court is not only incongruent, it runs directly counter to the idea of digitalization itself. In this regard, Hong Kong's courts have been moving decisively toward paperless and digital processes, with remote hearings, electronic filing, and digital case management. At the center is the Integrated Court Case Management System, ICMS, which has expanded significantly this year. Its purpose is to enable electronic handling of court documents and payments across all court levels. Through ICMS, users can file documents with the court, receive documents from the court, search and inspect filed materials and case information, consult course books, and make payments for court services. Implementation has been phased since 2022. ICMS already covers civil actions in the district court and bulk claims in the small claims tribunal. This year, it has extended to the High Court, starting with civil appeals and then intellectual property cases, personal injury claims, probate actions, and, especially relevant here, general civil actions, construction and arbitration matters, and commercial actions, where use of e-bundles for trials has been mandatory since 2022. Commercial parties can now use ICMS to conduct the full suite of filing and case-related tasks online, removing the need for paper submissions and visits to court buildings. This marks an important step towards end-to-end digital dispute resolution in Hong Kong's courts. Indeed, the High Court offers enhanced ICMS features. Originating documents can be generated using fillable electronic forms rather than scanned uploads, simplifying case initiation. Organizational users have access to judiciary-hosted cloud storage for large files. They may also operate a judiciary deposit account, allowing pre-funding and the settlement of multiple transactions without repeated payment steps across different cases. While these details may seem modest, convenience and efficiency are essential to drive adoption. The judiciary expects to mandate e-filing via ICMS for legally represented parties from the latter half of next year, which should further increase utilization and improve efficiency. Further digital developments include e-apostille services launched in September, allowing electronic submission, payment, and collection without attending the apostille service office. In support of open justice, a 2-year pilot for live webcasting of proceedings has begun with the Court of Final Appeal. Most significantly for commercial dispute resolution, the Court's remote hearing ordinance commenced in March. It places on its clear statutory footings the Court's power to order remote hearings across all levels, building on experience from over 2,000 remote hearings since the COVID-19 pandemic. This clarity should encourage parties to adopt remote hearings, including from abroad, and give confidence that rights can be enforced by the Hong Kong courts without requiring physical attendance, with corresponding savings in time and cost for cross-border trade. In conclusion, it may be observed that whilst digital systems can record legal commitments accurately, obviously not every legal question is resolved by code and automated systems. At the same time, where a digital process replicates the substance of a legal act, courts can proceed much as they would with paper, and sometimes more efficiently, especially where the court process itself has embraced digitalization. Trade, without doubt, will continue to evolve, but the law will continue to ask familiar questions. Who undertook which obligations, who relied on them, and what should follow when promises and expectations are not met? If digital systems are designed to be legible to the law, and if courts engage with them in a measured and practical way, the digitalization of trade can progress with reasonable confidence. In this regard, the rule of law provides the conditions for that confidence. Known rules, records that can be understood, decisions that are accountable, and remedies that are effective. Keeping those elements in view is likely to be helpful. Thank you very much.
Thank you, Chief Justice Zhang. Please be seated. Thank you very much. Before we start the panel discussions, everyone please remain seated for a group photo. And can I please invite the photographers to board the stage? Everyone please follow the instructions from the photographers for the group photo. Thank you. Just a few more. Thank you very much. Ladies and gentlemen, the Judicial Summit 2025 consists of the Judicial Conference today and the Judicial Roundtable tomorrow. The Judicial Conference today features 4 panels examining different dimensions and benefits of legal instruments developed by the UNCITRAL that facilitate and harmonize the end-to-end digitalization of trade transactions, starting from digitalization of trade finance, including digital assets, the shift from paper-based documentation to paperless trade, the digital transformation of transport, and dispute resolution in the digital economy, DRDE. We will now move to the panel discussions. Now, after each panel discussion, there will be a Q&A session. So if you have any questions for our moderators and our speakers, you can scan the Q&A QR code on the screen and also on your table card to submit your questions through the online form. Our moderators and our speakers will address your questions at the end of each session. The first panel for today will focus on digitalization of trade finance and digital assets. May we now invite our moderator of this panel, Ms. Monica Canafaglia, Legal Officer of UNCITRAL. And also our speakers, please everyone welcome them on stage. They are Professor Yun Zhao, Professor Giuliano Castellano, Professor Xiaoping Zhang, and Dr. Marek Dubovec, who would join us remotely. Everyone, please join us on stage and make yourself comfortable. Thank you very much. Everyone, welcome. Ms. Canafaglia, the stage is all yours. Thank you.
Thank you. Thank you for having us here. Good morning, ladies and gentlemen, distinguished participants, those who are here in person, those who are online. I would like, before we start this panel, I would like to join the remarks made by the Secretary of UNCITRAL, Madame Joubin-Brett, who's my director, and express our heartfelt condolences for what happened, for the fire that occurred last week here in Hong Kong, and the solidarity with all those involved and with Hong Kong SAR. Welcome to this panel on digitalization of trade finance and digital assets. Just to introduce the panel, the point is, how do we build trust in a world where trade finance is going digital? So digitalization is with us. You've already heard it in the introductory remark, in the keynote speech. And it's transforming how value is created, represented, transferred in global commerce. From digital assets to tokens of various nature, technologies is reshaping the foundations of trade and finance. There are benefits in this process, such as potential for improved access to credit, especially for micro, small, and medium-sized enterprises, and also challenges. For example, legal uncertainty, fragmented approaches, and the need for harmonized standards. Today, our distinguished panel will explore how the existing legal frameworks interact with new forms of assets and digital practices. And we'll look at developments, we'll look at countries' experiences, we'll look at international organizations. I'm very pleased to introduce our 4 distinguished experts who are with me on the podium. Professor Zhao Yun, representative of the Regional Office for Asia and the Pacific of the Hague Conference on Private International Law. Professor Giuliano Castellano, Associate Professor at the University of Hong Kong and Director of the Asian Institute of International Financial Law. Professor Zhang, Associate Professor of Law at the Central University of Finance and Economics. And connected with us online, Dr. Marek Dubovec, Director of Law Reform Programs at the International Law Institute. Without further ado, I'm leaving the floor to Professor Zhao. Just reminding my distinguished colleagues here and Dr. Dubovec, we have a little less than what we had planned at the beginning, so please try to stick to 10 minutes each so we can have time for questions. Please.
Thank you, Chair. Good morning, ladies and gentlemen. It's a great honor for me to be here to talk about the digitalization of trade finance and virtual assets. The push towards digitalization of trade finance involves replacing traditional paper-based rules documents with electronic records. And the rise of virtual assets actually presents challenges and opportunities for commercial and financial law. My presentation today will examine how virtual assets intersect with existing legal frameworks and explores the evolving legal framework of digital assets, including enforcement of rights and their financial implications. International organizations like the UNCITRAL, UNIDROIT, and HCCH have been actively working to modernize laws in this area, producing model laws, principles, and projects to guide national reforms. As the Chief Justice Andrew Chun has just stated, while UNCITRAL and UNIDROIT provide substantive and legislative foundations, the HCCH ensures that these frameworks operate effectively across borders through rules on jurisdiction, applicable law, and recognition of judgments. Traditional trade finance has long relied on paper documents which are costly and inefficient in the digital world. Digitalization offers fast, more secure, and cost-effective trade processes. For instance, switching to electronic trade documents can reduce processing times from weeks to days. Studies estimate enormous economic gains if legal frameworks are aligned with modern digital trade laws. SMEs stand to gain better access to finance and global markets once high paper-based barriers fall. The UNCITRAL Model Law 2017 provides a legal framework to give electronic transferable records the same legal status as paper originals. It ensures that electronic records can fulfill functions of uniqueness and control analogous to possession of paper documents. In other words, the model law defines technical criteria so that an electronic record can be subject to control from its creation until it ceases to have effect. These guarantees one original exists in electronic form, preventing duplication, a critical feature for negotiable trade documents. By adopting laws based on the model law, countries remove legal barriers to paperless trade, unlocking efficiencies and new financing opportunities. The purpose of this model law is not to invent new types of commercial instruments, but to provide a robust legal framework that enables the use of electronic equivalents of existing paper-based transferable documents and instruments. It achieves this by establishing clear principles of functional equivalence, ensuring that an electronic record can serve the same legal functions as its tangible counterparts. As such, the model law is a foundation for domestic legal recognition, but global enforcement requires coordination through HCCH mechanisms. Digital assets generally refers to digital representations of values that can be transferred, stored, or traded electronically. In legal discourse, the focus is on digital assets that are subject to control and uniqueness rather than just end data. For example, UNCITRAL described digital assets as essentially a collection of data in electronic form that a person can have a right or interest in. This could range from simple digital files to complex crypto tokens. The key legal feature that makes these digital assets functionally akin to traditional assets is their transferability via exclusive control. In practice, control is achieved through cryptographic keys or system rules that ensures only the holders of the key can dispose of the asset. Courts now recognize crypto as property, and the trend is to define this to be a new category for data subjects. Enforcing legal rights or court orders against digital assets poses unique difficulties. Unlike a physical asset, a crypto asset is secured by a private key and may be held in a decentralized network or in custody in another jurisdiction. Key enforcement considerations include, for example, courts are adapting traditional remedies to digital assets. To seize or enforce against a digital asset, one typically needs control of the private key or cooperation of an intermediary. Courts have recognized this reality. In jurisdictions where exchange or wallet providers are involved, courts can order these intermediaries to freeze or transfer assets. In purely peer-to-peer contexts, enforcement may require compelling an individual to divulge keys. HCCH frameworks are increasingly relevant to overcoming these cross-border enforcement barriers. The core HCCH conventions and instruments aiming to enhance access to justice, access to finance, and facilitate cross-border cooperation in the area of financial and digital laws. These are the conventions: the 2006 Securities Conventions, 1985 Trust Convention, and 2015 Principles on Choice of Law in International Commercial Contracts. The HCCH also has launched several key initiatives in recent years. For example, the Digital Economy Project since 2021, examining how private international law interacts with DLT and FinTech. The Digital Tokens Project explores jurisdictional connecting factors for tokenized system and DLT. In March 2025, the CGAP adopted conclusions and decisions which states that mandated the establishment of an expert group to study the private international law issues raised by digital tokens, subject to available resources. These projects aim to ensure that digital assets are governed by predictable and interoperable conflict of law rules worldwide. Digital assets are inherently borderless. The network nodes are globally distributed. The owner could be anywhere, and the location of the assets is hard to pin down. This makes it challenging to determine which country's law applies to ownership and transfers, and which court has jurisdiction. Traditional conflict of law rules are not easily applied. This is why the HCCH has launched a study on law applicable to cross-border transfers of digital assets. The goal is to develop coordinated guidance or even a treaty on how to choose the applicable law for digital asset transactions to ensure consistency and predictability internationally. For example, they can consider approaches like the law of the issuer's jurisdiction for certain tokens, or the law chosen by the parties, or perhaps an entirely new connecting factor. This work is still in the exploratory stage, but we can see that it's rather important and crucial for enforcement. If a dispute arises or a security interest is asserted in a token, all parties need to know which country's laws and courts will decide the matter. Enforcing a judgment against digital assets often requires cross-border cooperation. In this regard, I think tools like the 2019 HCCH Judgment Convention will facilitate recognition of judgments, so a court order obtained in one country against a crypto thief or debtor can be recognized in another country where the exchange or custodian is located. In summary, enforcement is evolving. Legal systems are stretching existing mechanisms and creating new ones to deal with virtual assets. International coordination via conventions and model laws will be key to closing enforcement gaps. In this regard, the HCCH's work should help to complete the last mile for the UNCITRAL model law implementations and global interoperability. The rapid pace of technological change has prompted unprecedented cooperation among international law bodies to ensure a harmonized global approach. In this regard, I would again mention about the three international intergovernmental organizations. First, UNCITRAL has taken the lead in modernization. In recent years, UNCITRAL adopted a cutting-edge model law to facilitate digital trade. It also updated the legislative guide to illustrate how to handle new forms of assets. Notably, UNCITRAL conducted a legal taxonomy of digital economy issue to map out what legal questions arise with technologies like AI, data, online platforms, digital assets, etc. So UNCITRAL is actively assessing whether additional international legal standards or guidance should be developed to deal with digital assets in commerce. Second, UNIDROIT. UNIDROIT complements UNCITRAL by developing detailed principles and model laws on specific areas of private law. In 2023, UNIDROIT adopted the principles on digital assets and private law. These principles provide non-binding but authoritative guidance on foundational private law issues, how to define digital assets, how to transfer the digital assets, how to treat custody relationships, etc. And third, HCCH, which focuses on private international law issues, ensures that as domestic laws diverge or evolve, there are common rules to resolve cross-border issues. HCCH launched the Digital Economy Project, and of course, as I've mentioned, HCCH is well suited to tackle all these issues related to digital economy, digital token, CBDC, etc. Additionally, HCCH has also launched the Codify conferences, which gather experts to discuss issues like jurisdiction over blockchain disputes, the interplay of trust law, securities laws in the age of tokenization, the roles of existing HCCH conventions in the digital assets context. All these efforts aim to ensure that when disputes or transactions across borders, which they inevitably do in the digital assets space, there are clear rules to avoid chaos and litigation that ends. Collaboration and coherence is rather important among these three international organizations, and indeed, they are coordinating their work. The UNCITRAL legal taxonomy explicitly notes that it was finalized in consultation with HCCH and the UNIDROIT. Yes. And the UNCITRAL, UNIDROIT, and SHH form a three-legged stool for building a coherent legal framework for the global digital economy. In conclusion, the digitalization of trade finance and advent of virtual assets are transforming commerce, and the law must keep pace. UNCITRAL's instruments have laid the groundwork for electronic trade documents to be used with the same confidence as paper, removing legal uncertainty that hinder digitalization. The intersection of virtual assets with commercial and financial law is precisely where international cooperation is proving its worth. And for practitioners, financiers, and governments, these developments brings great legal certainty. As a final takeaway, the digitalization of the trade finance and the rise of digital assets demonstrates that law is not static. Through UNCITRAL, UNIDROIT, and HCCH, the international legal community is proactively adapting principles of commerce that have served for centuries: negotiability, property rights, legal certainty to fit the digital age. So with this, I conclude my presentation. Thank you very much.
Thank you, Professor Zhao. And with no further ado, I'm giving the floor to Professor Castellano. And presentation will probably focus a little bit also more on digital assets per se.
Okay. Thank you very much. It's truly an honor to be here, and thank you to the organizer. And well, because we are, conscious of time, I'll go straight to the point of my presentation. What I've been trying to do today is essentially to put into context how digital assets can be used, and in particular, considering the possibility of using digital asset as a form of collateral. In other words, a digital asset in a place where the economy is increasingly digitalized can actually become an asset class that potential borrowers can use, and in particularly SMEs can use in order to access to collateral. To do this, I will focus on a specific class of digital assets that do not have a counterpart, and I will show that actually there is the need for a coordination within different aspects of the law, including regulatory law. Regulatory law intended as the administrative framework that generally is providing for the rules for providing financial services such as credit extension and so on and so forth. We will show that essentially the coordination between private law rules and regulatory rules is fundamental to generate trust, exactly the trust that Honorable Secretary of Justice was mentioning as a foundation for this type of new economy. Well, the existence of digital asset is essentially coming from the digitization and digitalization, two different phenomena of the economy, right? In a sense, by putting everything on a digital platform, we start to have asset that can be used, that can be traded for different purposes. They are becoming mainstream instruments, and then we can think about instruments that have a paper counterpart, as well as new type of digital instruments, such as those based on distributed ledger technology. As a result, we do have the growing use of this asset as a financing tool, but we do also have a very large category in terms of private law terms and in terms of also economic terms of digital asset. And ultimately, we can include a large variety of assets. We do have the electronic transferable records, which actually generally reflect a paper counterpart, as we heard just until today. So we do have a possibility to actually transfer, not creating new asset, but actually to recognize that what it was done in paper form can actually be done in digital form. But then actually we do have also other type of assets that do not have a paper equivalent. And here I'm mentioning too, like tokenized assets, where there is a digital representation of real world value on a distributed ledger technology. This can be a bond, this can be a tokenized bond, this can be an asset that actually isn't on the distributed ledger technology but represents something else, an entitlement on a piece of property, whether a financial instrument or something more tangible. We do have the increased use of stable coins. Stable coins are becoming more popular for payment system, for remittances, as well as for a number of other transactions. And then there are growing experiments in the region, in Hong Kong and beyond. So we have essentially two, well, if we split between private law and regulation, we can identify a series of tenets, a series of core principles, some of which, for instance, Professor Zhao already eloquently mentioned. We will look at the private law. We have the functional equivalence approach, which is contained in the Melita. We do have the principle of control, also contained in Melita, and the UNIDRA digital asset principles. We do have this idea also of technological neutrality. When we look at regulation, we can see that at G20 level, and then with the different type of organization involved in drafting technical standards, we have a core principle that is the same activity, same risk, same rule. In other words, the regulatory effort at the global level are trying to bring within the regulatory perimeter assets that are used in a way that it resembles what we know already, like typical financing mechanism, such as collateralization, such as using digital asset as a type of collateral in order to access the finance. The main difference here is that when we look at the international regulatory standards, such as those elaborated by the Financial Stability Board, by the IOSCO, by the Basel Committee on Banking Supervision, we enter in a more detailed categorization. So we do have rule specific that define what is, for instance, a stable coin, what is a central bank digital currency, what are different type of other tokenized assets. So what happens when we take this type of asset as collateral? Well, we do have international standards. So, for instance, the UNCITRAL model law on secured transactions is perfectly applicable to this type of assets in principle, in a sense that actually it applies to any type of movable assets, right? So digital asset, even those that do not have a paper counterpart, do fall into the definition of movable assets. We do have a number of specific regulatory provisions that has been increasingly implemented around the world, and then actually they are establishing different criteria for anti-money laundering, for criteria for custodian, and then even more capital requirements for banks that actually are using, having an exposure on different type of digital assets. When it comes to the implementation at the domestic level, we, however, start to see that there are some issues if we simply rely on existing international standards. We do have a regulatory framework that has been very fast in reacting at the international level in order to ensure the safety and apply the principle of same activity, same risk, same rule. But we do also have, we can see that when we try to implement, for instance, the model law on secure transactions, we might have some doubt, some uncertainties on the meaning of possession. And therefore, we need to complement that with something different, like the meaning of, the idea of control. Yet, also in that case, we might have some gaps because there are the uncertainty, for instance, on what are the rights on underlying asset. In the context of a stablecoin, it will be, for instance, quite difficult to determine whether the holder of the coin also has a right on the reserve. So, how this is solved? And I want to offer here the case of Hong Kong very briefly. The idea is that we do have a clear, quite sophisticated legal system based on the common law. And then upon that legal system, upon that private law system, different type of regulatory provisions have been adopted in a unified way. This is very clear if we, for instance, we juxtapose, as I've been trying to do here in this slide, the decision of the landmark decision, I would say, on Gatecoin, where actually the court established that effectively digital asset without paper counterpart can be actually property capable to be held on trust. And it's precisely upon this notion that actually the regulatory framework that, for instance, govern the licensing, the custodian, the segregation of digital assets and the protection for customers, especially in the context of insolvency, has been built upon. Similarly, in the stablecoin ordinance in Hong Kong, it has been expressly stated that actually the redemption, the reserve that are represented, that are held in an intermediated entity are effectively capable to be, must be segregated via trust agreement, precisely referring to the principle of common law already present in Hong Kong. So, what are the key takeaways? And this is essentially my conclusion here. First of all, when we deal with digital assets, we need to remind ourselves there is no single silver bullet, but different pieces of legislation that are effectively governing different type of assets and different type of transactions must be taken into account. These is largely addressed, for instance, by the existing and the future works of international organizations, but actually something more must be done. This is, for instance, is why UNCITRAL has been looking on future works to actually adapt the UNCITRAL model law on secure transactions to different type of digital assets in order to clarify what happens when such an assets are taken as a collateral. The last, I guess, message I would like to share with these distinguished audience is that the interpretation we give on private law rules do impact the financial stability, consumer protection, and the integrity of the financial system, because actually determines how risk is effectively transferred, used, and priced within the mainstream economy. And the other way around, regulatory provisions do need to consider effectively what are the private law premises upon which a given legal system allows for the circulation, the use, and the adoption of this type of collateral. And with that, I conclude. Thank you very much.
Thank you, Professor Castellano. That's been a very interesting, discussion on digital assets and their role in secure transactions. Our next speaker is Professor Zhang, and I think that with Professor Zhang we will also have a little bit more of insights on legislative progress within the context of a jurisdiction. So we will even more look into the domestic challenges and even successes of this. Thank you, Professor.
Yeah. Chairperson Ms. Monica California, honored guests from various jurisdictions across Asia and the Pacific, panelists, friends, and colleagues. Thank you for the opportunity to speak today. We're living in an area defined by digital economy, which has connected each of us across the border and sectors. Against this backdrop, I'm delighted to share insights into the latest development of China's digital legislation with the sincere hope that these observations will prove valuable to our discussion today. I'll keep it short. I'll try to. In China's civil code, it only stipulates that where other laws protect data and online virtual assets, that law should be followed, without saying the legal nature and to what extent the protection should be given to the legal assets or data, to the digital asset or data. On that, meanwhile, Article 25 of China's national security law emphasizes ensuring security and controllability of information system and data in key sectors. So these two basic laws delineated boundaries of data protection from dual perspective of privacy and security, respectively. Additionally, as you may know, that some provisions from People's Bank of China or Central Bank clarify that virtual currency traded in China are not recognized as legitimate assets. So generally, this is what you, if you only look at text of the law, this is the general landscape. However, China is a country experienced rapid development in the digital economy, which has consequently created urgent pressure to respond with clear solutions. To avoid too much details, I will proceed directly to the conclusion that China has achieved some clarifications and breakthroughs through policy documents and local legislations. In 2022, the CPC Central Committee and the State Council adopted and issued opinions on establishing a basic data system on better play the role of data as factors of production, commonly referred as in China as 20 provisions on data. The document proposing that we establishing a property rights operation mechanism featuring the separation of three rights: the right to hold data resources, the right to process data, and the right to operate data products. And meanwhile, it's emphasized fully protecting the legitimate right and interest of data originator. In particular, it seeks to safeguard rights and interests arising from data generation and reasonably protect the data processor's right to hold and to duplicate data. The concept and practice for this right separation system, as well as the protection of data's originating rights, has been embodied in many local legislation, such as the legislation of Hangzhou and legislation of Shenzhen. And if we look at from this perspective, it seems that China's core of China's data legislation, or rather the core of the digital protection, seems to lie in the conflicts, tensions, and coordination between personal rights and property rights, as well as interests sharing among data originators, holders, processors, and operators. However, such an understanding still fails to provide a clear perspective on what digital assets are and how should they be protected. What propels me to think further is a question, or rather a phenomenon. Sometimes protecting personal privacy and information proves conducive to data protection itself, while at other times there seems to be a certain tension between the two. We need to identify a deeper framework to explain the seemingly contradictory phenomenon that coexist and manifest differently across various scenarios. After rigorous reflection and extensive discussion with some Chinese experts, we contend that all these phenomena might be explained by following framework: the distinction between information and data. Information refers to the content, the description of the world, or description of human minds and thoughts, while data constitutes the form or the carrier or the vehicle of such contents. In essence, data serves as tangible medium through which information, the meaningful core, is stored, transmitted, and expressed. At this point, I suspect that many of you may immediately raise the question: even if we acknowledge the difference between data and information, does this necessarily mean that they require separate legal protection? Before addressing this question, let's turn back to legal history. I'll use an analogy to illustrate my point. As we know, humans have engaged in various forms of transactions since ancient times, giving rise to a range of debtors-creditors relationship. We even use document of this debtor-creditors relationship as collateral for financing, a phenomenon that has existed for a long time. It was not until much later that, as the carrier or the instrument of this creditor-debtors relationship became more complex and more standardized in form, a new law branches emerged, the law of negotiable instruments, that is, bill of exchange, promissory notes, and checks. We know that creditors-debt relationships themselves are governed by contract law. However, the form, the proof, and manifestation of these obligations in transactions are embodied in the law of negotiable instruments. This serves as a crucial illustration of the way that why both content and form require simultaneous regulation by different areas and sectors of law. I acknowledge that my train of thought may be a little bit abrupt, but please allow me to finish. This content and form dichotomy clarifies the basic framework of data law, which compromise an internal system and an external system. The internal system are the data's four functions, that is, control, possess, process, benefit, and dispose. The external system, by contrast, refers to the relationship between data law and those rights relates to the information, to the content. Specifically, the rights we have repeatedly mentioned, for instance, personal privacy rights are essential individual rights over their own information. Intellectual property rights of enterprise are, in essence, enterprises' rights over their creative information they hold. Of course, there are other more complex scenarios, such as those antitrust, anti-unfair competition law affairs, but I think with more further explanation it can be handled. A crucial legislation and policy implication of this dichotomy is even if data rights are explicitly stipulated by law, this should be a highly restricted set of rights. In exercise of these rights, the content-based rights, privacy, IP, for example, must be respected, and such rights shall not be infringed upon. I believe that this constitutes the core principle of China's data legislation, and consequently, which means data law is akin to dancing on the knives of age, navigating a very narrow path where the balance between protecting data as a form and protecting other information as the content. Let's turn back to China's legislative landscape. So we have external system in civil law and national security law, and we have an internal system in the CPC and the State Council document, and as well as the local legislation. In today's talk, I have to plan originally to say a few words of digitalization of trade finance. I'm afraid I have to skip that part. To a conclusion, a question had long perplexed us. Is legislation a subjective or objective endeavor? While legislation in form, undoubtedly it reflects subjective design and choices, there must be an underlying object logic guiding all such decisions. Discovering this logic clarifies broader landscape and enable us to anticipate further developments with greater clarity. Before I conclude, I would like to make a disclaimer. The views expressed above are my personal observation. They do not represent a position of my university, nor do they reflect official stance of Chinese government. We will wait and see with great anticipation, and I look forward to further sharing updates of China's legislative progress regarding digital address with all of you in the future. Thank you for your attention.
Thank you, Professor Zhang. That's been very interesting. Travel into the challenges and future expectations of mainland China on this topic. And without further ado, now passing the floor to Dr. Dubovec. He will guide us to another topic linked to, of course, digitalization and trade finance, and his presentation will also focus on warehouse receipts. Dr. Dubovec, I don't see, I saw you, but now you have disappeared from the screen. Can I assume you're there?
I am here, if you can hear me.
Yes, we can hear you very well, and please go ahead.
Wonderful, and thank you very much to the organizers for inviting me to share my views on some aspects concerning the digitalization of trade finance and digital assets. As Monica said, my presentation focuses on one type of digital asset, which is an electronic warehouse receipt, and hopefully provides a smooth transition to the following two panels that delve more into the details of trade finance in the context of goods that are in transit, while my presentation focuses on the financing of goods that are in storage. So I will focus on an enabling framework for commodity finance, as most types of goods that are deposited in warehouses and against which digital receipts are issued are commodities. So let me first provide a bit of a background and then proceed to the examination of some of the relevant international standards, particularly focusing on the UNCITRAL and UNIDROIT model law on warehouse receipts, which was proposed at the 2017 UNCITRAL Commission by the United States government and co-sponsored by Mexico and eventually supported by a few other delegations, reacting to the developments on the ground, as many more jurisdictions at that time already had functioning warehouse receipt systems as well as digital warehouse receipts, typically traded on some type of an exchange, such as the EWR that was established in the United States over 30 years ago, or the London Metal Exchange, or the Dalian Commodity Exchange, which utilized warehouse receipts to settle commodity transactions such as futures contracts, as well as many ports around the world that have already the infrastructure at the time to process and issue and transfer digital warehouse receipts. So what are the current international standards that govern this part of trade finance? I'm going to start at the bottom, as those were the documents that led to or provided rather the inspiration and sources for the 2024 Joint Model Law on Warehouse Receipts. So at the time, we had available some guidance from the World Bank Group, the European Bank for Reconstruction and Development, and FAO for all sorts of stakeholders, including policymakers and financial institutions, on how to establish and operate warehouse receipt systems, but we quickly realized the type of guidance became outdated. I should also mention the UNCITRAL model law on electronic transferable records, colloquially known as the MLEADER, that will be subject of the next panel. The implementation of the MLEADER could provide an effective mechanism to digitalize warehouse receipts that are already recognized by legal systems when they're issued on paper. Then in 2023, UNIDROIT enacted or adopted principles on digital assets and private law that Professor Yoon mentioned in his presentation opening this panel. There is Principle 4 that provides for a linked digital asset that hypothetically could be used to digitalize warehouse receipt, but as I will briefly mention on my final slide, the DAPL would not be an ideal vehicle for the digitalization of warehouse receipts, for which we have an ideal vehicle to be the joint 2024 UNCITRAL model law and UNIDROIT model law on warehouse receipts. So let me briefly explain some of the core features of this model law. It applies to both paper-based as well as electronic receipts in a medium-neutral manner. Several speakers already at the summit mentioned various principles that underpin significant UNCITRAL instruments of technology neutrality or functional equivalence, and several of the UNCITRAL instruments are also based on the medium-neutral approach, which results in a set of rules that apply to paper documents and a set of rules that apply to electronic documents, which was a conscious choice of the working group at UNCITRAL. The second core feature is its application to primarily negotiable receipts, as that is the objective of many projects at UNCITRAL, including on negotiable cargo documents, which is to bestow the quality of negotiability and document of title on several documents that could be used as collateral in trade finance. However, the model law also applies to non-negotiable receipts that are primarily issued by collateral management companies and are not used to transfer ownership or other property rights in goods. The third core feature is transfer by way of control, which essentially copies the elements and requirements for control from the MLETR. Typically, the systems for electronic warehouse receipts operate based on a registry system, so a governmental entity provides the registry infrastructure through which individual warehouse operators then issue and manage electronic warehouse receipts, which is somewhat different to other types of trade finance instruments and documents, as we'll hear more about in the next two panels. And then finally, I wanted to highlight an essential feature of the model law, which is the status of a protected holder, which the keynote speech also highlighted in the context of protecting third parties who acquire digital assets in good faith. Under the model law, a person may become a protected holder if that person satisfies three requirements, which is to acquire control. So control plays a significant role within the model law. The person must also act without any knowledge of competing claims or any defects in the goods or the instrument itself. And the person must also act in the ordinary course of business. So if that person then satisfies these three requirements, it may become the owner of the warehouse receipt, or it may become a secured lender, as often secured lenders actually satisfy these requirements so as to take free of any competing claims. This is my final slide, where I wanted to highlight the reform approaches that jurisdictions have taken and could take going forward, hopefully implementing the model law on warehouse receipts. As I mentioned a few minutes ago, the DAPL of UNIDROIT is a good instrument for the digitalization of what I would call generally crypto assets, Bitcoin and Ethereum, in other words, for transactions, for financial transactions with digital assets. For a well-functioning warehouse receipt system, and there are many around the world, the jurisdiction may simply adopt the MLETR that would cause or result in the digitalization of that well-functioning system. However, in the recognition of many warehouse receipt systems around the world being outdated, the MLETR implementation would not bring about the desired benefits, and those jurisdictions are encouraged to implement the model law on warehouse receipts that provides not only the digital elements, but also modern features necessary for commercial transactions. As Professor Castellano mentioned earlier on our panel and highlighted the need for convergence between private law and regulation, this is a specific example of that convergence in the context of warehousing, where in fact many laws are not limited to private law aspects, but also deal with a variety of regulatory aspects, such as the licensing of warehouses, and the guide to enactment to the model law on warehouse receipts provides some examples as to how that regulatory framework or the system for warehouse receipts may be constructed. All of these individual core elements that I mentioned on the preceding slide, and coupled with the regulatory aspects, are a precondition to the financialization and tokenization of commodities transactions that utilize goods stored in warehouses. We already have many exchanges and platforms for electronic warehouse receipts and similar tokens that perform the function of warehouse receipts. So the model law is a necessary framework coupled with the regulatory overlay for the financialization and tokenization of commodities transactions. Thank you very much for giving me the opportunity to share my views.
Thank you, Dr. Dubovec, for guiding us through the model law warehouse receipts, actually, which is a fairly new instrument, and the results of a coordination between UNIDROIT and UNCITRAL. We still have a few minutes, and I'm glad for that. So I have received a few questions that I would like to ask all of our panelists. The first one is actually how can Hong Kong, as a common law jurisdiction, balance its legislative innovation, rather investor-friendly, with China mainland civil law that is actually taking a different approach. Can we maybe start from Professor Zhang and then we go this way, since your presentation, in fact, focused a lot on China mainland?
I'm trying. As for we divided that law in two parts: private law and the regulatory framework. For private law, I think when we walk in the window, I think we can find some common grounds, because take window as an example, that they have members of working group from both civil law countries and common law countries. And they talk from the perspective of private law and try to figure out the rules that can be acceptable for most of the jurisdictions. That's one thing. Another is that I still think there may be a little bit difference between China and Hong Kong, and not so undesirable, because sometimes this causes flexibility to the investors who invest both mainland China and Hong Kong. So far, that's my opinion. Thank you.
Thank you very much. Professor Castellano?
Yes. I think this is a
very good question. And the idea is that we are within one country, two systems, right? So on the private law side, as Professor Zheng correctly indicated, we do have common grounds, no matter whether we are common law, civil law, actually there is the participation. In a context of the one country, two system, however, there is also the possibility to develop specific different regulatory approaches when it comes to digital asset, as long as those are in line with international standard. For instance, China was one of the most strong advocate for having international standard for anti-money laundering for digital asset, or as they call it, virtual asset in that context, and then ultimately has been implemented worldwide in order to actually ensure market integrity, even though in China in mainland China certain type of digital assets are actually prohibited. And then we do have instead in Hong Kong the implementation of this type of anti-money laundering rules. So the idea is that the two are perfectly, we can have synergy in a sense, and especially this will allow Hong Kong to explore certain type of assets and their implementation for this different business practice.
Thank you. Professor Zhao?
Thank you. I think when it comes to China, I would say I think this is the ideal place, I think, to talk about the issue of legal convergence. I think we can see that in the Greater Bay Area, so we have one country, two systems, and 3 jurisdictions. So we will have to take a very pragmatic and evolving approach. Now I think today we are talking about digital assets as a high technology field. Probably I think that this, of course, I think not only we are looking to the technical side, but in general. I think in general, I remember, I think we're looking to various channels, very approach that we can do. For example, we're talking about the setting up international coordination committee. We are looking to possible guidelines or model law for the 3 jurisdictions. So that is general, I think, which have been discussing for various times. I still remember, I think, a few months ago, I also talked about the legal convergence with regard to the ODR within the GBA, etc. So I think that is one part. Now, we're not looking to the technological aspects. I think that at least we can look into several approaches. First, we're looking to the technological neutrality approach. So this really helps. The second, we also talk about the functional equivalence. So I think these are specifically to look into. That means I think we are not really talking about the civil law jurisdiction or common law jurisdictions, but technological, there are some common features. So that's the first 2. And third, would again, I think, talk about the private international law issues. We talk about the party autonomy. So first of all, we always emphasize party autonomy. No matter we have the international coordination committee, model law, etc., we should highly respect the party autonomy. Afterwards, of course, after party autonomy, of course, we will look into the connecting point and also how to define the connecting point. So I think these are something we will need to look into. Yeah. Thank you.
Thank you very much, Professor Zhao. So I would like to, since we have here 3 experts on Hong Kong and China mainland, I would actually ask Dr. Dubovec to start replying this question. Do you think that digital currency, and I will also add digital assets, will be the future?
Well, I think the digital currency is now. We're not talking about the future. As Professor Castellano mentioned, stablecoins already play a prominent role. So just to give you specific examples, not so much in the context of digital currency, but in the context of trade finance, because this is the focus of our panel, there are many applications that I have studied that have been already deployed to, for instance, replace the functions traditionally played by letters of credit, so that the bill of lading or other transportation or storage document is locked in through an application and a smart contract embedded with certain conditions that are triggered on the and the payment is triggered on the satisfaction of those conditions, essentially mimicking the functionalities of the traditional letters of credit, and the payment is effectuated through stablecoins. So we are already grappling with those types of applications, and we're trying to fit the law of negotiable documents or negotiable instruments that was devised for the transactions of the 19th century to these new transactions of 2025 and 2026. So in answer to your question, the future of digital currencies and digital trade is already here.
Thank you. Thank you for this. Actually, future is already here with us. And with these last remarks, I actually would like to thank all the experts here on the podium with me, and I pass the floor back to the coordination officer, if I can say so, for the next panel. Thank you very much.
Thank you all for that insightful sharing. Can I please invite everyone to remain in your seat as we have a group photo before we send you off? Thank you very much, everyone. Thank you very much. Everyone, please be seated. Thank you. Please be seated. Thank you for that insightful sharing once again. Everyone, we will now take a 10-minute break where refreshments are available outside the hall. Everyone, please remember to take your valuables with you when you leave. And for online participants, please stay logged in as our next panel session will start at 11:45 a.m. Thank you very much, and we will come back. Ladies and gentlemen, as we resume our program today, can I please just gently remind everyone not to give applause or clap during the session so we can maintain a solemn atmosphere to show respect to those affected by the fire in Taipo last week. Thank you very much. Now, our next panel is on enabling paperless trade, the UNCITRAL model law on electronic transferable records, MLETR, which will be moderated by Ms. Athita Kuminder. Thank you very much. She is the head of UNCITRAL Regional Center for Asia and the Pacific. Joining Ms. Kuminder are four panelists. We have Professor Mason Song, Ms. Marjorie Yang, the Honorable Justice Aiden Su on the stage, and we also have Dr. Alan Davidson, who's joining us online. There will be a Q&A session at the end of the panel discussion where you can scan the QR code on your table around this hall or on the screens to submit your questions. So without further ado, I'll pass the time to Ms. Kuminder, please.
Thank you very much. Good morning, distinguished panelists and guests. I'm Athita, head of the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, located in Incheon, Republic of Korea. It is truly my honor to serve as moderator for this session. Before we begin, I join my colleagues in expressing condolences for the losses caused by the Taipo fires and thank the DOJ team for continuing to extend their very best efforts to ensure the success of the Judicial Summit in these sad times. So the previous panel has made my job very easy, already having illustrated the bridge between how UNCITRAL instruments support digital transformation of trade finance via the UNCITRAL model law on warehouse receipts, and how they support the use of digitalized commercial documents by governments via the UNCITRAL model law on electronic transferable records, MLETR, the focus of this panel. Adopted in 2017, the MLETR, together with other UNCITRAL digital trade instruments, set the global standard for establishing a legal framework supporting digital trade, as demonstrated by the commitments of states and jurisdictions in bilateral and multilateral digital trade agreements to establish and maintain laws consistent with those texts. For example, the APEC ministers responsible for trade and the ASEAN Digital Economy Framework Agreement, both reference the MLETR, with members encouraged to adopt the MLETR. Currently, 12 jurisdictions have formally adopted the MLETR as documented on the UNCITRAL website, with over half of those in the Asia-Pacific region. And a much larger number of jurisdictions are on the way to adopting or already implementing the main provisions of the MLETR, of which we will hear about today. I also refer you to a dynamic tracking tool by one of our partners, who will also speak later today in this event. So for a dynamic overview of global adoption and implementation and ongoing consideration of MLETR, I refer you to the MLETR tracker on the ICC Digital Standards Initiative website at www.digitalizedtrade.org/MLETR. So turning to the panel, we are privileged to have four distinguished experts on the MLETR this morning, both with us in person and also online. The discussion will first commence with the foundational and philosophical elements of the MLETR, including what constitutes an electronic transferable record and other main legal elements of the MLETR. The benefits of the MLETR for paperless trade, finance, and transport will then be discussed from academic and commercial perspectives. And finally, judicial perspectives on the MLETR will be provided from the vantage point of Singapore as an early adopter. Each speaker will have approximately 12 minutes for initial presentations, allowing some time for discussion and Q&A. And as each speaker's accomplishments and distinctions are very full, I would refer you to the Legal Week website for their bios. So our first speaker is Dr. Alan Davidson, Chair of UNCITRAL Working Group 4, joining us online from Australia, who will introduce the foundational elements of the MLETR in the next 12 minutes. Alan, please, nice to see you.
Good. Thank you very much. It is a privilege, it's a pleasure to be here. I was at the last Judicial Summit, although I was also online at that time. I should first give my condolences and sympathies for this time of the tragic fires. People of Australia are watching that very closely and are very empathetic and have our best wishes as well. As you can see from this first slide, I trust it's up online there. I'm currently the chair of UNCITRAL working group 4, the working group that has been dealing with electronic commerce for some time. I wasn't chair at the time that Melita was drafted, though I was a member of the drafting group and I had a bit of a hand in drafting many of the provisions. It's interesting being part of the drafting group because you see not only what are the current words, but I can remember what our previous drafts were and how we arrived at a particular point in time. I will use the expression Melita for Model Law of Electronic Transferable Records. So forgive me for using that brief acronym, although Athita was doing the same thing. On my next slide, yes, here it is. Here are 6 texts from UNCITRAL. The great work that UNCITRAL does is to try to harmonise and stabilise and provide uniform laws in relation to international trade. They've been very successful in some places. Sometimes we write a particular model and it isn't as popular as others. Going back to the first one on this list, the Model Law of Electronic Commerce, its main purpose is to provide functional equivalence for paper documents so that they can be electronic. And that has been in place virtually 30 years now. The first country to adopt it and implement it was, in fact, Singapore. Singapore is often an early adopter. And now 171 jurisdictions have adopted some form of the Model Law of Electronic Commerce to provide that functional equivalence. It might raise the question as to why are we talking about a Model Law of Electronic Transferable Records if we have that law in place already? Because it deals with a different type of instrument. But just going through these very briefly, there's also a Model Law of Electronic Signatures, a convention on the use of electronic communications in international contracts completed in 2005, which I'll make a couple of references to. It duplicates many of the provisions in the Model Law of Electronic Commerce by providing functional equivalence to writing, to signatures, and other provisions dealing with contracts. I'm going to refer you to Article 2 in a moment, where it specifically excludes certain instruments by putting it into a hard basket and saying, let's deal with those later. And by dealing with it later, we did that when we did the Model Law of Electronic Transferable Records. Since then, we've got a model law on identity management and trust services, which will help facilitate the use of these other instruments, and a model law on automated contracting. But let's concentrate on that first one. I like this slide. I want to show you this slide in particular because I have to explain to some people that international trade is not just a buyer and seller and sending goods and handing over money. It is much more difficult than that. There is a huge friction costs of trying to get the goods from one place to another and information and going through government departments. This is a diagram on the left-hand side, which comes from an ASEAN document. So I've stolen it from there because I think it's excellent. In the middle, you'll see letter of credit, bill of exchange, commercial invoice, order form, insurance policy, bills of exchange, which is relevant for our purposes, as some of the documents which are used. On the left-hand side, you've got parties, importer, exporter, and I won't read them all, but there's many more parties that are often involved: banks, insurance companies, exporters, couriers, freight forwarders. On the right-hand side, which I'm sure you can't read, are each of the data field entries that you need to put on each of the documents. And of course, they're duplicated. Information that is in a letter of credit will be in the commercial invoice. And so there's, according to ASEAN, over 5,000 data field interactions. And it depends upon the type of goods and the types of permissions and the export certificates and the import certificates. And the friction of getting goods from one side or the other is the problem that we have. And it's been achieved by paper for a couple of 100 years. And now we're at a stage where the Model Law of Electronic Commerce can facilitate most of those documents to be electronic, but some of the documents it can't, because they are documents of title. It is a bill of lading that the possessor of it has the right to the goods, or the possessor of a bill of exchange, for example, has the right to payment. It is more than just a piece of paper with information. It is extra legal rights that's associated with it. And traditionally, we need to make that in paper. In fact, it's all about the concept of possession and delivery. And the concept of delivery is such an important legal concept that I'm giving you not just a piece of paper, but transferring $5 million worth of goods, or a bill of exchange that could be for $50 million or something like that. The principles underlying it, because part of my brief is to talk about what are the foundational principles, is this simple concept of functional equivalence. And I often just simply say, if the electronic version serves the same function as the paper-based version, it should be treated equally by law. So that sounds also like the anti-discrimination provision, because it's really about parties' intentions. If I intend this document, whether it be a transfer, whether it be a contract, a transaction, a certificate, to have a certain effect, then it's the intention behind the paper document and the information on it, which would be the same if it was in an electronic format. If it serves that same function, it should be treated equally by law. UNCITRAL typically makes sure that it's technology neutral. And that is, it doesn't say, please use this technology or that technology or blockchain, because the moment we would say that, someone's going to invent new technology and it will be out of date. It is trying to describe in all of its laws, in all of its models and its conventions, the function. And if you achieve that function, then you can achieve it by using whatever technology that is available. Sometimes it's also referred to as the non-discrimination principle, that a document should not be denied legal effect solely because it's in some type of electronic form. This permeates from the model law of electronic commerce, the model law of electronic signatures. You know, if the electronic signature serves the same function as the handwritten wet ink signature, it should be treated equally. The convention and all of our instruments. I want to make a comparison, if I have time in my 12 minutes, with the convention that's recently come out on negotiable cargo documents, which does something slightly different. When we look at these principles, we need to go back to the model law of electronic commerce, the MLEC, and what I call the ECC, the Electronic Communications Convention of 2005. To understand those is to help us to understand MELITA, because you must have laws in place that talk about functional equivalence of generally writing and signature before we get to one that talks about electronic transferable records. Now, when we're talking about the type of documents that MELITA is addressing, we're familiar, of course, with bills of lading, bills of exchange, promissory notes, warehouse receipts, dock receipts, anything that really has an obligation that is attached to it or a right attached to it that on delivery we are transferring it. In writing MELITA, we were very conscious that we were not trying to rewrite any laws. Whatever the law is about a bill of lading, we want it to remain the same, whether it's paper or electronic. Substantive local law remains unaffected. Again, I'd like to compare that to a negotiable cargo document where they are deliberately trying to change the laws. But for our purposes, if it serves the same function, we just look at the information and the signatures on the electronic version to see if it satisfies the laws of bills of exchange. Because the only intent is to facilitate electronic commerce. And it will save billions. I want to get onto that right at the end, where the reports, the economic studies talk about billions of dollars being saved, of changing a transaction which might take 55 days down to 5 days. In fact, some places say 1 or 2 days. So far as the legal side of it and the transfer of information is concerned. And that type of efficiency translates into a huge cost saving. One report, and it's so massive, I almost find it hard to believe, to say that once it's completely adopted, in the first 10 years, $1 trillion will be saved by commercial parties. But even if that's wrong by a factor of, say, 10, a lot of money will be saved in that regard. I mentioned I was going to talk about the Electronic Communications Convention, which provided functional equivalents for writing and signatures and others. And they said, what are we going to do about these transferable documents and instruments which have these rights associated with it? And they decided they don't know what to do. So they put Article 2, Sub-Article 2, into the convention that says this convention does not apply to bills of exchange, promissory notes, consignment notes, bills of lading, warehouse receipts, or any transferable document or instrument that entitles the bearer or beneficiary to claim delivery of goods or payment of a sum of money. Because they put it in a too hard basket and said, we'll have to figure that one out later. It's a little bit like if I send you a PDF document by email, I also keep the PDF document. We needed to have the technology in place where once I electronically gave you something, I no longer had any control over it. Some of you might be sitting there going, of course, blockchain does that. Blockchain was invented by an article by Satoshi Nakamoto in 2008, so after this convention came out. The model law of electronic transferable records is not reliant on blockchain or that type of technology, but it is a good example of the technology that can be used to have integrity, that when we transfer something electronically, we can trust it. Indeed, people trust it with billions of dollars with Bitcoin. You will accept a transfer of Bitcoin because of the technology, underlying technology that works. One of the key definitions is, what is a transferable document or instrument? I've already described it a few times. I do like this definition, and I want to compare it, you see at the bottom of the slide, with the Electronic Trade Documents Act of the UK. I think I've just got a bit of time to do that. A document or instrument issued on paper that entitles the holder to claim the performance of the obligation indicated on the document, or some right. Now, it actually comes from the United States, and they considered that a transferable instrument relates to money and a transferable document relates to goods. That's not necessary, and we didn't do that. But it is a very generic statement that if we have this instrument that exists, that has this obligation, then the model law of electronic commerce, when implemented in countries like Singapore and China and the United Arab Emirates and Papua New Guinea and Mexico, will be treated equally. My concern about, I raised the Electronic Trade Documents Act. The UK decided to go down their own path and write their own version. They are using the principles from Melita, but they did not want to use the wording for their own personal reasons. And just on this one definition, they have a definition of a paper trade document, is what they call a transferable document or instrument. And they said that this act, to provide functional equivalence, will apply to paper trade documents. A paper trade document is of a type that is commonly used in the UK in trade. And when I first read that, I thought, why are they limiting it to that? You mean that they can recognise there might be other paper trade documents, but if it's not commonly used in the UK, the Act will not apply to validate it. Their explanatory note says it was meant to include Scotland in their particular list. And I'll give you one example. I can give you about three, but I don't have time, I don't think. And that is, if country A is dealing with country B in international trade, and they say that the law of the UK applies, which is a very common thing that happens in international trade, that means the Act will apply. But if they're using a document or instrument that is not commonly used in the UK, the Act will not validate it to allow it to be electronic. The broader definition of Melita applies to any type of instrument. It was meant to be international. I would encourage Australia, as I have done with the Attorney General's Office, and other countries to say, let's try and be uniform and use one set, so we know that these countries have adopted Melita and they've largely, 98%, if not 100%, used the same wording, so that we are harmonising and making it easier and much more stable. Article 7 has a very generic statement in Melita. An electronic transferable record shall not be denied legal effect, validity or enforceability on the sole ground that it is in electronic form. Functional equivalence, anti-discrimination. The key provision, I guess, is in Article 11. And we did debate this for a long, long period of time. In fact, not just in one session, but over several sessions. The electronic record, number one, the electronic record must contain the information that's required to be in the paper-based document. So we're not changing substantive law. If it's a bill of lading, it's got to have the same information and usage as the substantive law. And you must use a reliable method, which is defined in Article 12, to identify an electronic record as the electronic transferable record. An electronic record is any type of file, but it becomes this operable instrument when it becomes an electronic transferable record. I've actually underlined the word "the" because we really debated that for a long period of time about having the word operative electronic transferable record or authoritative electronic transferable record, but we just said if it's an electronic transferable record, it is operative. But we ended up with the word "the." And to render that electronic record capable of being subject to control. Elsewhere, it talks about exclusive control because the concept of possession is, from an electronic point of view, is control, and to retain integrity of that. And also, we're talking about the transfer of that control as being the equivalence of delivery. Here we go. Possession equals control, actually exclusive control. Transfer of possession means delivery, the transfer of control. For the purposes of functional equivalence, it's quite, dare I say, elegant in how it works. It's odd to me that we finished writing it in November 2016. The Commission adopted it in 2017. Countries like Singapore adopted it quickly, but there's like 5 years of almost silence, and now it's taking off around the world. I've particularly been associated with APEC, where they're recommending they all use it. I don't want to read this, but what a reliable method means is as reliable as appropriate, using 7 factors that we debated, and the bottom one, sorry, the 7 factors are an ex-ante approach, and proven in fact is an ex-post approach. You can prove after the event that it occurs. So these are some of the countries that have adopted it. You'll see I've got G7 there. The G7 said that they want to adopt it as well. I've been involved with Tuvalu and Tonga. Just 2 weeks ago, you see the bottom of this, on the 14th of November, there are 9 Attorney Generals in Australia, 6 states, 2 territories in the Commonwealth. They released a communique saying, we will now formally write the same wording and will adopt it in Australia, though it might take them to 2027 to do that. One last point, there is this, I think, very good paper, and it's got that very long title about analysis of the legal gaps and economic benefits in relation to Melita, put out by APEC, a 95-page report, quite thorough. I have written a fair bit of that, but what I think is more exciting of it is the economic part of that, which tells you all these benefits, and there's a link to that. That, I hope, is an introduction to it. I think one judge has said there's no cases about it yet. Hopefully that's because it's so robust, we won't have too many fights. Madam Chair, back to you. Thank you very much.
Thank you very much, Alan, for laying the groundwork for us. And we now move to continue that with Professor Mexian Song, Associate Professor at Dalian Maritime University in China, who will discuss other key elements of the Melita, including continuing this discussion on control and also possession. So Mexian, the next 12 minutes are yours, please.
Thank you. Thank you, Athesa. Good afternoon, good morning, ladies and gentlemen. Following Dr. Davison's talk, my presentation will focus on my academic views on the impacts of the Melita on domestic laws governing electronic bills of lading. I will analyze the divergent approaches that some national legislation have taken regarding the concept of control of electronic bill of lading. So where are we now with electronic bill of lading? The international group of P&I clubs have so far endorsed 14 electronic bill of lading platforms or systems, while 3 predate blockchain era, and the rest of the 11 systems approved since 2019 are blockchain-based. As Alan just mentioned, one of the key 3 basic principles of Melita is technology neutrality. Here, blockchain is not something we are particularly pro, but blockchain is a very special product because it has addressed some concerns of the users in the market. And I have to be precise that among these 14 electronic bill of lading platforms, one platform has since been discontinued, primarily for commercial reasons. So the trend reflects a broader digital transformation in trade and transport, where data now flows seamlessly within dedicated ecosystems rather than being fragmented across paper documents. So from technological perspective, stakeholders are particularly concerned about reliability, security, and interoperability among various platforms to avoid perpetual lock-in. Economic speaking, we have to admit that the electronic platforms generally requires relatively high investment and poses significant entry barriers for both operators and users compared to the paper system. Legally, the use of electronic documentation is generally not prohibited, but this is not good enough because stakeholders are seeking certainty and assurance. So all these 14 electronic platforms has been endorsed by IG, operate on a legal structure that relies on domestic legislation as backbone, complemented by sophisticated contractual networks. So about international efforts, so I won't repeat what Alan has just mentioned at the UNCITRAL line of model laws in facilitating electronic commerce, but highlight in this panel is Melita 2017. Melita deals with electronic transferable records. The legislative adoption based upon Melita is believed it is facilitated a wider use of electronic bill-of-lading as seen in Singapore and the United Kingdom. Singapore incorporated Melita in its Electronic Transaction Amendment Act 2021, this EA 2021. UK has specifically enacted Electronic Trade Documents Act 2023, ETDA 2023, but it used a different concept, namely electronic trade documents. So in the transport sector, the CMI Uniform Rules on Electronic Bill-of-Lading 1990 is known as the first attempt to address electronic bill-of-lading. And so far as I understand, based upon my limited knowledge, the law of South Korea has been governing law of electronic bill-of-lading based upon the 1990. So in the Commercial Act of the South Korea, it directly used the word electronic bill-of-lading, not electronic transfer records or something else. And another international convention, also from CMI, is not become effective yet, but we all understand it's very advanced milestones. That is the Rotterdam Rules, the United Nations Convention on Contracts for International Carriage of Goods, wholly or partly by sea. It was drafted as a media neutral. It was drafted it passed in 2008, and the treaty fully supportive electronic transfer records. Yes, it used a different term. It used the term as electronic transport records. And this term also appears in the newly revised Chinese Maritime Code. Right, despite this variety of terminology, there are electronic transferable records as in Melita, there are electronic trade documents as in UK ETDA 2023, and there's electronic transport records as in Rotterdam Rules, as well as the newly revised Chinese Maritime Code. We understand they all encompass the electronic bill-of-lading. So now, my second task today is to discuss about control and possession. Possession is the word we use in the tangible world, physical possession of the paper bill-of-lading or any paper documents. Control we use in the virtual era means that we're holding or using or operating on the electronic data. So in my presentation, I will look into the topic of document control, which is distinct from the concept of control of goods in transit. Here we're not controlling something tangible, we're controlling something intangible. I have chosen this topic is because, so far as I understand, the fundamental change introduced by an e-bill-of-lading as opposed to its paper counterpart is the medium, from a tangible to intangible assets. So the first panel has already dealt with the intangible assets issues, but here I'm going to address this functional equivalence, the recognizing the legal effect of a electronic documentation, whereas the paper counterpart have already been in existence. Right, exclusive control for e-bill-of-lading is associated with the issues of singularity, integrity, reliability, and even interoperability, all these things, the terms we used in the modern electronic bill-of-lading law-related issues. So I will follow Alan's presentation. Article 11, Alan gives Article 10, and Article 11 of Melita is about control. It says, A reliable method is to establish exclusive control of electronic transferable record by a person. And I read this Article 11 with the explanatory notes of Melita, because Melita is also accompanying with its explanatory notes. Paragraph 106 and 107, I bring your attention to those two paragraphs. 106 says the notion of control, which is closely related to the requirements contained in Article 10, paragraph 1b2, is not defined in model law, since it is the functional equivalent of the notion of possession as in the paper. And in turn, it may vary in each jurisdiction. So the word or the legal understanding of possession may vary across jurisdiction, but in this particular concept, my understanding is actually not. Because paragraph 107 makes it very clear that model law is concerned with identifying a functional equivalent to the fact of possession. Fact in possession as opposed to legal possession, which means legal possession, it means a possessory title or possessory interest. We have to admit it is vary across jurisdiction. But when it comes to matter of fact, physical control or physical possession of something tangible, it is something we recognize universally across jurisdictions. So in line with the general principle, as 107 continues, in line with the general principle that model law does not affect substantive law, local laws, the notion of control does not affect or limit the legal consequences arising from possession. Consequently, parties may agree on modalities for exercise of possession, but may not modify the notion of possession or the notion of control in itself, referring to merely a matter of fact. Right, now let's move on to the UK ETDA from the comparative perspective. So in the UK ETDA, possession and control is also a defining concept. Section 2 and Section 3 of the ETDA defines the control of data or electronic bill of lading is equivalent to the possession of the paper. And under English law, the use of possession encompasses two primary meanings. The first pertains to physical control of the asset, while the other refers to legal interest or formal title. In the first meaning, physical possession or exclusive control makes little difference. My conclusion is, in both ETDA and the Melita, control refers to a state of fact, not a legal right. The legal effect of actions exercised in electronic systems are effectively relied upon the existing rules of the paper bill of lading. And the existing rules of paper bill of lading and the property law in each jurisdiction, that is something varies. That is something different across jurisdictions, not the idea of possession or control. Right, if I do have some extra time, I do want to mention about the revised Chinese Maritime Code, which will become effective next year, 1st May. And as Mr. Tian Ya mentioned in the opening remarks, there's a specific section in Chapter 4 of the CMC dedicating to electronic bill of lading. But the word used here is following the terminology of the Rotterdam rules, which is transferable transport records. But however, as Mr. Tian Ya has highlighted, the Chinese Maritime Code had made reference to both Melita and the Rotterdam rules in this particular section. Right, there are 6 sections regarding electronic bill of lading in particular, and Article 85 of CMC Code, the new code will become effective next year, also mentioned that for a negotiable electronic transport record, a reliable method or reliable trading system shall be used to ensure the singularity, integrity of the record, and to ensure the holder's exclusive control over the record. Okay. Here, my conclusion, I'll conclude here. So in the short term, we will see a continued promotion and increase in the use of electronic bill of lading. That's the future. Certain jurisdictions motivated by desire to enhance their competitiveness in shipping and law have taken the lead in legislating for electronic trade documents or electronic transport documents. Although the use of electronic documentation is generally not prohibited, its effective adoption requires a comprehensive legal framework to govern its use. It is imperative for every jurisdiction to develop a legal regime for electronic transport documents or trade documents with a specific focus on establishing the legal concept control over them. Now, I conclude my presentation. Thank you.
Thank you very much for your foundational insights, Mexian, which add on so well to Alan's. So just to note that both Alan and Mexian had referenced the UNCITRAL instruments. So you can access those on the UNCITRAL website, uncitral.un.org, in the 6 United Nations official languages. So Arabic, Chinese, English, French, Russian, and Spanish. So you can look more at the Melita there, including the explanatory note and all the other instruments that we have on digital trade and other matters. So we now move from academia and laying this foundation for the Melita to a business perspective, including insights on where Hong Kong, China stands on its consideration of the Melita. Our third speaker, Ms. Marjorie Yang, is very well positioned to do so, as she is Hong Kong, China's representative to the APEC Business Advisory Council, or ABAC, and chair of ESCO Group. So Marjorie, the next 12 minutes is yours, please.
Thank you. First of all, I'd like to thank the moderator for facilitating such a constructive discussions on Melita. From the first two speakers, I've already learned a lot about this. I consider the topic of paperless trade and Melita particularly relevant to the current trade landscape, as efficient and effective cross-boundary digital trade is essential amid the increasingly complex global trade landscape and heightened trade tensions. In recent years, promoting cross-border paperless trade and the alignment of domestic laws with Melita has been one of the priorities of APEC's Business Advisory Council, which is ABAC. I am Hong Kong, China's representative to ABAC, and I am happy to see what began as an initiative driven largely by the business community is now gaining traction across governments, regulators, academia, and the legal sector, underscoring its importance. I am encouraged by this momentum and believe that our collective efforts can accelerate the extensive adoption of Melita. Digital trade is a subject not only critical to Hong Kong, but also to the regional development and the global economy. Traditionally, trade in the world is growing at a rate twice of that of GDP. However, in recent years, the growth of trade has slowed down. If the trend continues, it will be detrimental to the global economy, especially to the developing economies. Embracing digitalization is no longer a choice, but a necessity, especially as local traders navigate through the crosswinds of the US-China trade tensions. COVID-19, digitalization, including the development of AI and ongoing trade frictions, to name just a few, underscore the need for economies to continue to thrive. Upgrading the trade ecosystem and lowering trade cost through the digitalization of trade is widely recognized as a key strategy to promote trade growth. Nevertheless, the trade processes remain highly paper-based, hindering the progress of trade digitalization. This is largely because of the existing legal framework does not currently accord the same legal status of digital versions of negotiable documents to their physical counterparts. Consequently, a number of critical trade documents, such as the Bill of Lading, are still required to be physically delivered to various parties throughout the entire trade process. Moreover, businesses, especially SMEs, are encountering choke points in adopting paperless trade. For example, current digital platforms are usually supported by big carriers and banks, while small and medium-sized customs brokers and forwarders are rarely connected to them. The UNCITRAL took an essential step towards trade digitalization in 2017 by publishing Melita. This is a standardized legal framework that aims to facilitate the adoption of paperless trade by enabling the legal use of electronic records both domestically and across borders. It applies to electronic transferable records that are functionally equivalent to transferable documents or instruments which are essential commercial tools. Their availability in electronic form will help facilitate electronic commerce by improving speed and security of transmission, permitting the reuse of data and automating certain transactions through smart contracts. Electronic transferable records may be particularly relevant for certain business areas such as transport and logistics, as well as finance. They are also fundamental components to facilitate paperless trade. For instance, supply chains need Melita in order to completely digitize for traceability, financing, and speed. This is why APEC, as well as some regions such as ASEAN, are so committed to Melita, and why from an APEC perspective, the implementation of Melita is urgent. In Hong Kong, we have long been at the center of the region's supply chains, and we need to adopt this as soon as possible, not only to reinforce our position as a trade center, but also because so much trade goes through Hong Kong. If Hong Kong is not moving, we will cause a lot of delay in the overall process. At the same time, supply chains have grown more complex, while digitalization can be a key to manage them at scale. Moreover, Melita and digital trade are creating a new force in trade finance, which is critical to SMEs, especially for those who do not have a strong balance sheet. With the existing huge gap in trade finance, digital trade is changing the landscape of trade finance by shifting from balance sheet lending to transaction lending. With Hong Kong's traditional strength in both financial services and trade, Hong Kong can pioneer this new opportunity. Now that we have set the scene with regard to the importance of Melita for businesses, paperless trade and trade finance, it is crucial to also look at where things are now, particularly in Hong Kong. Melita adoption among APEC economies is at varying stages, with only Singapore, Mexico, Papua New Guinea, and the United States having implemented Melita or equivalent provisions, representing less than 20% of APEC's 21 member economies. On the other hand, there is growing commitment across APEC to advance Melita adoption. For example, China, Japan, and Thailand are active in the process of aligning their legislation with Melita. The relatively low adoption rate presents an opportunity for Hong Kong to unlock the economic benefits of paperless trade through coordinated Melita implementation. The Hong Kong SAR government has been promoting the digitalization of trade documents. For instance, it is developing the Trade Single Window to provide a one-stop electronic platform for the trade to submit various trade documents for trade declaration and cargo clearance. Upon full implementation, TSW will have the technical capabilities to connect with the single windows of other economies or commercial systems to facilitate exchange or reuse of data in various trade documents. To this end, the government is exploring opportunities to connect the TSW with the single windows of Chinese mainland and ASEAN. The government is also collaborating closely with the HKMA on the connection of TSW with HKMA's Commercial Data Interchange, CDI, to facilitate traders on trade finance through authorized sharing of their import and export declaration data. On Melita, the chief executive announced in his year's policy address that the government will introduce a legislative proposal with reference to Melita next year for the digitalization of B2B trade documents. The government is now in the process of drafting the legislation with reference to Melita and will soon consult the industry on the preliminary proposal. We look forward to the early completion of the legislative process and for the adoption of Melita in Hong Kong. In addition to the efforts of the government, Hong Kong's journey toward Melita has actually begun much earlier through business sector advocacy. As an executive board member of ICC, I am proud to share that the ICC Hong Kong has been advocating for Melita since November 2023, when it organized its first event on Melita to raise the importance and highlighted the business case. Since then, ICC has been working hard through business advocacy, awareness raising, and cross-government engagement to achieve the progress of today. To provide businesses with the relevant support, the Hong Kong Trade Development Council and ICC Digital Standards Initiative co-hosted a workshop for local SMEs this July, among others, to introduce the concept of digital trade, highlight the Hong Kong government's recent commitment in adopting Melita, as well as provide practical insights into digitalizing various sectors of the supply chain through platform showcases and product demonstrations. Furthermore, the ICC DSI is also launching a global digital trade sandbox, and I highly recommend businesses from Hong Kong to participate in. With all these resources for the business community, I strongly encourage businesses in Hong Kong to start preparing to practice the skills of digitalization supply chains as early as possible. Another key aspect is digital identity. I am glad to see that the government will set up a digital corporate identity platform to enable authentication of identity and verification of signature of enterprises using electronic government services or conducting online business transactions in a secure, convenient, and efficient manner without having to go through complicated procedures, thus saving time and reducing the risk of human error. Despite its benefits, it's crucial to ensure that the platform will be globally interoperable through the legal entity system, which is the only globally interoperable digital identity to date. I shall skip through, since I'm running out of time, I shall just go over quickly. There are also HKMA's Project Cargo X and other initiatives in Hong Kong. Hong Kong is fully committed. To conclude, the Hong Kong SAR government has announced its plan, reflecting its determination to implement Melita in Hong Kong, and the business community is fully in support, particularly of the SMEs to adopt this. With the unified goal of promoting the implementation of Melita and the adoption of digital trade, it is optimistic that concerted efforts from different parties would complement each other and create substantial impact. Thank you very much.
Thank you, Marjorie, for illustrating the commercial application and benefits of the Melita in Hong Kong, the Asia-Pacific region, and beyond, and also for sharing information about Hong Kong's current status. So, having heard from academia and industry, we now come to the judicial perspective concerning the implementation and interpretation of the Melita, most befitting of the Judicial Summit. So it is my honor to introduce Justice Aidan Su of the Supreme Court of Singapore. Justice Su is exceptionally well placed to discuss the Melita, not only because Singapore is one of the earliest adopters since 2021, but also because he is the judge in charge of transformation and innovation in the judiciary and chair of the Promotion of Legal Technology Innovation Committee of the Singapore Academy of Law. Justice Su, please.
Thank you, Aditha. Let me first begin by conveying the sadness and condolences of the Singapore judiciary to the people of Hong Kong for the tragedy last week. In my presentation, I hope to outline for all of you the position in Singapore in relation to our background, the likely issues for the courts, and the consequences of breach, challenges to compliance, issues in the use of ETRs, proof and evidence, and a brief touch on our Singapore-specific provisions. I must apologize, there's a bit of a common law bias in my presentation, but I hope that some of the issues and topics identified will be of use to civil law judges as well. An important aspect of the context in Singapore is the framework. So the model law was enacted in 2021 and is now been consolidated in what is referred to as the Electronic Transactions Act, or ETA 2010. It's now in Part 2A. What you must note is that the ETA covers more than just transferable electronic records. It also governs our electronic signatures and electronic contracts. So we meant for it to be part of an entire ecosystem. And that is also seen in some of the industry structures which our counterparts in the rest of government have been working on, particularly Trade Trust, which is aimed at facilitating the issuing and verification of ETRs, as well as other electronic documents and systems through the use of blockchains and non-fungible tokens. It's run by one of our statutory boards, the Infocom Media Development Authority, and the idea is to create an entire ecosystem that facilitates the use of electronic documents throughout trade. In addition, we've got the EU-Singapore Digital Trade Agreement, which again is not touching on ETRs directly, but is meant to again create the kind of ecosystem that facilitates the use of digital documents, digital assets throughout the entire relationship with the European Union. That is undergoing ratification. It's meant to align with Melita, and specifically it envisages trade documents being available in electronic form. Now, turning then to the judicial perspective, I must emphasize that I'm not saying that Melita is chock full of holes or that there will be issues from the get-go. I saw my role as helping to flag potential judicial issues. Melita does provide a robust framework, but importantly, as Dr. Davidson has highlighted, Melita does not supplant the general law in each jurisdiction. So the usual causes of action will have to be resorted to, for instance, breach of contract, and we'll have to confront issues in ownership, possession, and has been telegraphed in the earlier session, there might be issues arising in insolvency, fraud, negligence, and claims, and unusual claims in negotiable instruments. So for instance, in Singapore, we've had a number of cases arising out of fraud in the bunkering context with fake sales of non-existent or double sales of the same cargo of bunker or oil. And that sort of thing is not going to be preempted by Melita, not in any way. Those kinds of things will still arise. That is not Melita's purport. It's not intended to prevent such fraud, but it is intended to facilitate the trade and use of electronic documents. Consequences of breach are again left to the common law, and they're not laid out in Melita, so the possible consequences, at least in the common law context, will include non-recognition of electronic records through invalid documents or invalid transfers. Again, ownership rights may be affected, and ultimately it may resound in liability for losses. So as Dr. Davis has noted, we've not had any case law in Singapore. This could be testament to the robustness of the Melita framework, certainly, but it could also be a reflection of the fact that it's early days yet. These kinds of issues do take time to percolate through the system. We hope that Melita will be robust when the issues do crop up, but we in Singapore have tried to prepare for it regardless. Now, in terms of the issues as to compliance, challenges that might arise, certainly one possible area of contention between parties might be in relation to the reliability of the ETRs, as well as the issue of functional equivalence, which has been covered by the other speakers earlier. But I suspect, again, from a common law perspective, that the real battleground might be in issues of the equivalence between possession and control. Again, control, I think, is a robust concept, but we will have to see how it plays out on the ground in actual commercial dispute. There will, I think, be a lot of nitpicking about whether there's sufficient control in a specific situation, and that element of control is built upon the existence of reliable methods. So amongst the questions that a common law lawyer might raise in a dispute would be, is there really exclusive control? What could amount to instances or examples of diminished control, and what level of proof might be required? And I will go into a little bit of this in a subsequent slide. Another area of concern for me as a judge would be the change of medium, which is catered for under both Melita and the ETA, and you could have paper to ETR to paper, and I think each step of the process may actually throw up some issues on the ground. I can perfectly understand why you need to cater for this, especially given that different jurisdictions will have different comfort levels with electronic records, and you may need to allow for transition back to paper and back to electronic again, but that carries within it, I think, the seeds for dispute. Cross-border recognition is yet another issue, and again, that's been telegraphed by some of the earlier speakers in the earlier panel discussion. Different jurisdictions will adopt or may not adopt Melita at various points. It may lead to a lot of complications as we look at a lot of cross-border disputes. We will have to see how this pans out in a practical context. There are certainly mitigatory measures that could be adopted. For example, in the ASEAN context, we've had experience in trying to work out better channels of communication between courts, primarily in the insolvency context, in the admiralty context, and I think this is another area where the ASEAN jurisdictions could come together, at least the ASEAN courts, to try to ensure that when disputes arise in one court, we have a channel of communication open to other courts that might be involved in other aspects of the process to try to work out exactly what is happening and try to ensure that the pain that is encountered by the commercial entities is reduced as far as possible. The big challenge for us, I think, in terms of judicial disputes will be in proof and evidence. Expert technical evidence will, I put it as may, but it will certainly be required, and it's going to call for a lot of expert witnesses being briefed. It's going to call for a lot of expense. Very technical reports will probably have to be issued about the elements of control, about functional equivalence, and in Singapore context, probably about the accredited systems as well. What I should raise in Singapore is that we have a presumption of fulfillment requirements under our section 16(02) of the Electronic Transactions Act, which specifies that if the ETR system is managed through an accredited system, there is a presumption of fulfillment. So basically that means that the burden is shifted to the party that is alleging non-compliance. There are also other presumptions under our ETA and our Evidence Act. So this requires a rebuttal on the balance of probabilities generally. So it's not easily done in a commercial context. So we hope that this will help make things a lot easier for those relying on ETRs in Singapore disputes. So accreditation is an important part of what we have. It's actually available in relation to other aspects of our Electronic Transactions Act. What I have to flag is that the accreditation provisions in relation to ETRs is still being implemented on the ground. That, from my understanding, they are trying to get some technical specifications worked out, but the intention is to put it in place before too long. So again, to recap, what we hope in Singapore is that through this accreditation system, we give some assurance to the robustness of the systems that are put in place to implement electronic transferable records. So the primary takeaway I would have in relation to the Singapore context is that Melita is a robust and conceptually sound framework, but I think it has to be understood that Melita is just one aspect of the system, and it has to be accompanied, I think, by other legal frameworks as well as other operational frameworks, and that's what we've been striving for. And in addition to that, in relation to the judiciary, it has to also be taken on together with training and familiarization of the judges, which we, in the Singapore context, have tried to do through programs run by the Singapore Judicial College and other ad hoc events to try to make sure our judges are up to speed, especially in relation to technical issues. So thank you very much. That's a quick run through, and I'll be happy to take questions later. Thank you.
Thank you very much, Justice Su, for that very important judicial perspective. Also, a reminder to those participating here who might be less familiar with UNCITRAL, we have a case law on UNCITRAL texts. So there are no cases on Melita yet, but there are cases on other UNCITRAL instruments from various jurisdictions across the world. But you're welcome to look at these for free on the UNCITRAL website in the 6 UN languages. If you come across a case interpreting UNCITRAL provisions, including Melita, we would be so happy to receive it. So you can send that to uncitral@un.org. We have several questions from the audience, actually, that I see here on my control iPad. So I will just read out all the questions, and maybe the panelists could then pick and choose which ones you would like to answer. So, should Hong Kong position itself as a global sandbox for digital asset experimentation or as a harmonization bridge for the evolving CBDC ecosystem? That's the first question. Then what is the relationship between Melita and I think it's the model law on warehouse receipts? Do warehouse receipts fall into the range of transferable records? The next question, as ETRs gain global recognition under frameworks like Melita, what are the key challenges of implementation, particularly in aligning market practices with ETRs? How might jurisdictions that adopt Melita leverage it to strengthen their role in facilitating digital trade and distinguish themselves in the global landscape? What role can international cooperation play in ensuring cross-border enforceability of e-transactions? How far can differences across jurisdictions in requiring proof of control be accommodated? What is the mainstream approach to control? And are there any cases where trade trust gives evidence on the reliability of the tool? So those are the set of questions, very interesting questions we've received from the audience. So I don't know who would like to take a first crack. Oh, thank you, Margie.
Always goes first, hoping that you get the one question that you know the answer to. It's my exam practice. For big companies, I would like to see everybody to participate and join, because right now, my company has joined in a pilot with Standard Chartered Bank for several years. It is not really value creating now because in fact it is duplication of effort, because you have to have both paper and electronic. But on the other hand, during this pilot, you learn from it and you sort out a lot of the problems. I hope that all MNCs will do this. And I think a good place to do it would be wonderful if it could be done in both Singapore and Hong Kong. And because we have a lot of both common law jurisdictions and the banks, for example, Standard Chartered, they're all in both countries. So there's a lot of trade that is going on, and we can build a lot of case studies from that. So that would be my answer.
Thank you very much. Maxine?
Okay, I will go after Marjorie. So I'm going to mix or mingle a few questions together, just general observations. So the last point I made before concluding my presentation is electronic bill of lading or electronic documents is the future. That's the truth. So there's basically no going back to the paper documents as forever. So I was involved in a project with Costco Shipping, just one single company. So why I'm mentioning blockchain is before blockchain 2019, electronic bill of lading was evolving really slow for various reasons. But after blockchain has been adopted and applied since 2019, it is really evolved and developed very quickly in the past 5 years. And for cost ownership in one country, the issuance of bill of lading, electronic bill of lading, is booming. So globally speaking, that's going to grow very, very fast. Of course, we can leave it not governed by law because we need to develop customer usage for a bit of time. But anyway, because we already have paper bill of lading, that's why Melita is important, because it set the ground rules of functional equivalence. The law of bill of lading has been evolved for like 300, 200 years. So on this basis, electronic documents or transport documents or trade documents is not without any ground. So it can grow fast with the right principles laid down by Melita. As I said, domestic law must make it more concrete. And then it is supplemented by contractual work by the users to allocate risks and liabilities and rights more clearly. So basically, my point is Hong Kong SAR will join, of course, must join. That's the trend. And the users and stakeholders will look forward to assurance and certainty in law in future. And that will support the facilitate the use of electronic bill of lading or trade documents in the future. That's it.
Thank you. If I could just add to that, really, it's just, as I emphasized, Melita is not a panacea. It doesn't solve everything, but it does, I think, go a long way to dealing with a lot of other problems. So it's not a 100% solution, but it goes a long way there. And together with the other frameworks and other mechanisms, it does help facilitate more trade. And I think that's very important for our part of the world. We've got 11 countries now in ASEAN. We've got the wider Asia-Pacific region. We've got a lot of trade going on with North Asia as well. And I think whatever we can do to put in place mechanisms that smoothen the transfer of interest, of money is actually to be encouraged, because that will just help pave the way for greater interaction and commerce throughout the region. Thank you.
Thank you very much. Alan, would you like to share some perspectives?
Certainly. Firstly, can you hear me?
Yes, perfectly.
Good, then I will continue. Wonderful session, and thank you very much for that I could be a part of this. There's a question about control, as I'm looking down at my phone, because I was accessing it on my phone. Control is partly proved because under Article 12 for the reliability method that we use. And I said that there are 7 factors that we debated for a long period of time to figure out what is a reliable method. And it's not an exhaustive list, it's an inclusive list. I think number 7 says, and anything else that might be appropriate. But if you fulfill those first 6 and you've gone through certain audits and systems, you should know with a reasonable degree of certainty, if not absolutely, that you have met the reliability method and you know in advance that your system will work. I did say that there is an article, sub-article B, which says, or after the event, you prove that it did in fact work. And that's called an ex post test. But His Honour made the comment that in Singapore, they've added extra words into their adoption of Melita to set up an accreditation body. And I like this very much, and I've spoken with the drafter in Singapore about this, and indeed I know he's spoken with the Attorney General's office in Australia about this possibility, that rather than just leave it to a series of factors or proving after the fact, they will set up an accreditation body. And they will, you can say that if I use that method, which is approved by the Singapore government, then that will be considered reliable. We don't have to worry about whether we've completed the 7 factors or whether we can prove it after the event. It was news to me, His Honour just mentioned that they haven't finished that process, but it was legislated back in 2021. And that reliability method can apply, I think, for Melita, for all those type of documents, and perhaps into the future when Singapore and other countries might adopt negotiable cargo documents and warehouse receipts as well. I think Singapore should be applauded for that. That answers another question, saying is how can we perhaps lead the way? Singapore does that in some extent because they do legislate often early. They've also have a trade trust in place, which I think is a great scheme. But there are a lot of other players on the market that are trying to say our system is reliable, come and use it, it's electronic, we have blockchain or distributed ledger technology, and those companies in the individual countries are setting that up. The International Chamber of Commerce is also facilitating a lot of these steps along the way. I feel that I often talk about getting countries to adopt Melita, but organisations like the ICC talk about getting the actual commercial parties to implement the law that the countries have adopted. But I wanted to answer that question about control.
Thank you very much. Thank you very much, Alan. So I think we're just about out of time, and Alan also ended on a very important note about jurisdictions considering adopting the Melita or any UNCITRAL text. So for this, I would just like to highlight that the UNCITRAL Secretariat, my colleagues and I stand ready to assist those jurisdictions, both by providing capacity building and technical assistance and assisting with legislative drafting if so requested. So you can contact my office anytime with these requests, with these questions at uncitral.rcap@un.org. So with that, we end this panel. Thank you very much, Alan Online, Mexian, Marjorie, and Justice Sue for this fascinating and illuminating discussion. Thank you.
Thank you very much, everyone, and thank you, Ms. Kominder, for being our moderator. Everyone, please remain in your seat for the photo. Thank you again for that wonderful sharing. That was truly insightful. Everyone, please be seated. Thank you once again. Thank you. Please elect the stage. Thank you. Distinguished guests, ladies and gentlemen, thank you very much for joining the morning session of the Judicial Conference. For those who have been using the SI service and earphones, please leave the devices on the table or return them to the counter outside the hall. Whereas for in-person participants who require CPD points or ALE points, please present your QR code outside the conference hall to sign out to confirm your attendance record. Now this afternoon will begin at 2:30 p.m. Therefore, please do return to this conference hall by 2:25 p.m. When leaving the conference hall, please do take all your personal belongings with you. Now for online participants, please join us again at 2:30 p.m. Guests, please do enjoy your lunch break and we will commence later. Thank you very much.
原聲，原聲，原聲，一、二、三、四，一。Oscar 喺度，Oscar。你喺度啊？有冇啊？哦，你攞隻耳機。攞隻耳機係。好，而家我係呢個翻譯員。阿 Kara，你可唔可以細聲數
1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，咩？係咯，繼續1、1、2、2、3、3、4、4，1、1、2、2、3、3、4、4，1、2、3、4，1、2、3、4。點解我咁核突嘅顏色嘅你？1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，1、2、3、4，2、3、4，1、2、3、4，1、2、3、4。Hello， 1、2，1、2、3、4，1，好。先未翻嚟 ，thank you。
但係佢哋又冇入嚟㗎嘛。
但係咧，有一個 channel 咧 set 咗係英文 to 呢一個 version， 就唔係 audio default version， 唔知點解。咁但係理論上應該唔緊要嘅，因為咧應該頭先而家揀應該得翻呢3個揀嘅啫。頭先係多咗一個，多咗個 audio default， 咪多咗個唔知乜鬼 English 嘅，唔應該出現。即係話呢個 show 裏面只可以有2個頻道，就係英文或者 version。
auto default 嗰個就係
應該就會係英文嗰邊喎。係啊。咁所以一陣間你叫佢哋一陣間早少少入嚟再試一陣，點解可以試一陣？咁呢個唔好攞走住。好，我 keep 住先。好。
差唔多落翻去，準備
stand by。
because we believe that this key legal reform could potentially unleash the digitalization of trade globally, because it enables documents of title. Hello.
Good afternoon, ladies and gentlemen. The afternoon session of the Judicial Conference will commence shortly. Everyone, please be seated and switch your electronic devices to silent mode. 各位嘉宾，下午的环节即将开始，请就座并把手機或者電子產品調到靜音模式。各位嘉賓，下午嘅環節即將開始，請各位就座並將手機或者電子設備調到靜音模式。The Judicial Summit will be conducted in English, and simultaneous interpretation in Russian, Putonghua, and Cantonese will be available. On-site participants may collect headsets at the hall entrance. Please note that you can select Channel 1 for English, Channel 2 for Putonghua, Channel 3 for Cantonese, and Channel 4 for Russian. Also, online participants can select preferred language channel on Hong Kong Legal Week website. It is recommended to use headphones for better sound quality. 今天的高峰会将以英语进行，并提供俄语、普通话及粤语的即时传译。如果需要耳机，请到入口服务台领取。请注意，频道1为英语，频道2为普通话，频道3为粤语，频道4为俄语。线上的参与者可以在網頁的畫面選擇語言的頻道。我們建議你們使用耳機，這樣收聽的效果會更好。今日高峰會將以英語進行，並提供外語、普通話及粵語即時傳譯。如果需要耳機，可以到入口服務台領取。請注意，頻道1為英語，頻道2為普通話，頻道3為粵語，頻道4為外語。線上參與者可以喺網頁畫面上面選擇語言嘅頻道。我哋建議你使用耳機，咁樣收聽效果會更加好。For participants who would like to apply for the CPD points and ALE points, please sign in and sign out at the reception counter. Thank you very much for your cooperation. Also, please be kindly reminded, only in-person participants will be eligible for CPD points and ALE points. On the screen, you will see the QR code to access today's program. Please make note. Thank you very much. Good afternoon, ladies and gentlemen. Welcome back. As we resume our program, may I gently remind everyone not to give applause or clap during the session so we can remain a solemn atmosphere to show the respect to those affected by the fire in Taipo last week. Thank you very much. Having discussed the digitization of trade finance in digital assets and enabling paperless trade, the UNCITRAL model law on electric transferable records, known as MILITA, in this morning's session, our third panel will focus on digital transformation in transport, draft UN Convention on Negotiable Cargo Documents. Now, this panel would be moderated by Dr. Ling Yang, thank you very much, the Director of Hong Kong International Legal Tenants Training Office, Department of Justice, Hong Kong Special Administrative Region, People's Republic of China. Now, joining Dr. Yang are panelists, Mr. Edward Liu, Professor Naki Hyun, Judge Haiyan Ao on the stage, and we also have Ms. Pamela Ma and Ms. Yang Ying Li will be joining us online. Now, there will also be Q&A session at the end of the panel discussion where you can scan the QR code on the screens to submit your questions. Therefore, without any further ado, I'll pass the time to Dr. Yang. Thank you very much.
Thank you. Good afternoon, everyone. I hope you have had a very good lunch. And I'm Ling Yang, Director of the Hong Kong International Legal Tenants Training Academy of the Department of Justice, Hong Kong SAR. On behalf of the co-organizers, UNCITRAL and the Department of Justice, I welcome you to panel 3 of the Hong Kong Legal Week 2025, Digital Transformation in Transport, the draft United Nations Convention on Negotiable Cargo Documents, NCD. This topic is especially timely with the supply chains becoming increasingly multimodal and digital. The absence of the unified legal framework for negotiable documents of titles has long been a practical challenge. The draft NCD convention was approved by UNCITRAL in this July and now before the UN General Assembly. It is a significant step toward harmonizing rules across rail, road, air, and sea, and towards supporting both paper and fully electronic negotiable documents. So today, we have a very diversified panel with 5 distinguished speakers from the judiciary, academia, the maritime industry, and the international organization. They will share insights on the legal gaps the NCD Convention seeks to fill, how different jurisdictions may implement it, and what issues may arise as the digital systems and the pilot project begin to take shape. So please allow me to briefly introduce our speakers today. We have Judge Dr. Oh Haiyan. She is from the Supreme People's Court of PRC. She handles foreign-related commercial and maritime matters, as well as a judicial review of arbitration. She has long been part of China's delegation in the NCD negotiations. Next to Dr. Haiyan is Professor Naki Hyun. Professor Hyun from Seng Kun University Law School. She served for 15 years as a judge, including research judge in the Supreme Court. And Professor Hyun is an expert in civil procedure and international litigation, and has participated in UNCITRAL sessions as a Korean governmental delegate. Next to Professor Hyun is the only male speaker for this panel, Edward Liu. Edward is a principal representative of the International Chamber of Shipping China Liaison Office and a partner of Haiwen and Partners Hong Kong office. So he is the leading maritime and trade lawyer with extensive experience across arbitration and transport law. So I understand we have another speaker, Pamela Ma. Pamela Ma is traveling today, and she is not able to come to Hong Kong in person, but I would like to introduce Pamela. And Pamela is the managing director of the ICC Digital Standards Initiative. She leads global efforts to harmonize and digitalize supply chain standards and bring over 20 years of experience in global trade and sustainability. And we also have Yan Ying. Hi, Yan Ying, can you hear us? Yes, Yan Ying is online right now. Yan Ying is a legal officer at UNCITRAL and the secretary of the working group 6 under NCD. So she has been closely involved in the development of the NCD project since 2019. So without further ado, firstly, I would like to invite Judge Dr. Oh Hai Yan to take the floor to introduce some background of the convention and China's position on this convention.
女士们、先生们，尊敬的各位嘉宾。
So, ladies and gentlemen, good afternoon. It is my great pleasure to be here at this summit and exchange ideas with you on this on the subject of the draft United Nations Convention on Negotiable Coupled Documents on the digital transformation in transport. In the past 7 years, we have the fortune to have witnessed the coming of this draft from the very beginning to the existence. As the first speaker, my job is to talk to you after having this proposal of the UNICITRAL, how we have been working on the application of this treaty, where is it from, and where it will go. So in July 2019, the Chinese government submitted to the UNICITRAL the first legislation suggestion. That is the first suggestion put forward by the Chinese government to the UNICITRAL, and this proposal is on the rail transport, particularly from China to the Europe area, because the transport documents are different from the documents for the ocean transportation. It's different from bear lading, and for the rail transport, the functional limitations of these transport documents have become a great barrier and a very big difficulty for the importers and exporters because of they are not transferable. Because for those who claimed the goods, they must be the consignee of this document, and they have to have the effective document in order to claim the goods. For those non-equity or those non-registered consignee, even if they have the document, they cannot claim the goods. So therefore, the document is not the same as the document for sea transport. They are not transferable, and the title of the goods cannot transferable because of the document as well. And also, the document is not allowed to use as the pledge for any collateral. And back 30 years ago, for the pioneers of the sea transport in China, encountered similar problems. So at that time, they tried to work on something for the rail transport. They just like the shipless consignee mechanism. They just wanted to develop a similar mechanism without any train, without any road transportation. And for the block, because of the development of a block train from China, particularly from Chongqing to Europe, there came an invention of this the railway bill-of-lading featured document, hoping to help the importers and exporters expand their business. Here in this document, you can see that this is how they trade with each other. For the importers from China, as well as exporters from Germany, they buy and sell cars. In order to realize the transaction, importers have to work together with the forwarders, as well as the guarantee companies, usually the logistics companies. They have to sign a business agreement, and they have to agree that the bill of lading for the railway transport have to be an exclusive a document for the goods claims. Meanwhile, the importer and their bank have to enter into the second third-party agreement, and so that the banks can provide the foreign exchange services. Logistics companies have to provide a guarantee as well. Meanwhile, according to the forwarder, they have to receive their goods and provide the relevant documents. And banks have to pay as entrusted and provide the bill of lading, and so that the whole process can go forward. The importers have to use the bill of lading to claim the goods. However, it is agreed that the delivery of the bill of lading of a rail is considered as the delivery of the cars, and then the seller claimed the cars from the forwarder, and the forwarder refused, and then the buyer sued the forwarder company to the local court, asking them to pay to deliver the goods. So actually, for this case, it attracted a lot of discussions at that time because in this case they involved two tri-party agreements. Usually, the agreements are only binding to all the signing parties, not the non-parties. This case happened in China. Even if we use the rules as set by the Chinese property law to support the demand or the claim by the plaintiff, and if this case is handled by another country, will the complaint get the same support? At that time, it was agreement settled by the parties. And in China, according to China's law systems, the agreement is not a counterparty, and it needs the law to guarantee its effectiveness. So therefore, it aroused a lot of people's attention because of this consideration. So at that time, we found that there's a strong demand from the market on the liquidity of the goods. So please look at this slide. So at the 42 session of the 6th Working Group meeting by the UNCITRAL, you can see the Chinese delegation put forward this diagram, and you can see how this document flow from one party to another as step by step. So the UNCITRAL thinks that it is very helpful, and they discussed and found that putting aside the sea transport, other ways of transportation also faces the similar issue, that is the transferability of the documents. So how they can do to extend this approach, the resolution from one country to another, to one mode of transport to another. So therefore, originally it was called the transferable transport document. Later, the name was changed into the transferable goods multi-linked documentation. So as for the transferable goods receipts, for me, it is a super receipt or super document. The transfer of the document actually means the transfer of the title of the goods, and the document holder will enjoy all the rights and interests as stipulated by the document. The UNCITRAL has an in-depth insight on this, and the market was very responsive for this. In July 2024, one of the suppliers in Kazakhstan supplied wheat to an importer in China because both parties agreed that there will be a prepayment, and because the importer had a very big difficulty of cash. At that time, the Bank of China Jiangsu branch proposed a dual-way financing plan, and they suggested that the businesses use a fiat EFDL, that is the International Federation of Freight Forwarders Association, and they conducted the first pilot according to this treaty. On the 19th of October this year, I was in Dalian attending the China Marine Law the Marine Commercial Law meeting, and I noticed that COSCO in China worked together with the Dalian Marine Affairs University. They issued the first transferable document, that is the China COSCO Shipping plus the Dalian Maritime University. They released the model of a negotiable cargo document, and they also promoted the first application of this NCD, or the electronic NCD, so converting from a paper to electronic form of document. So from this model, you can see that we can have a seamless conversion. So being a part of one of the delegates of a Chinese delegation, I am very confident on the prospect of NCD because the success of international maritime issues resolution is based on the demands in the market. If the market needs, and then it will be successful. So we are judges. Our job is to apply the right law to handle the cases. In the past years, the Chinese court have been working hard to handle different cases by adhering to international laws, and we apply the right laws and the regulations and have handled some typical cases where you can see our concept, principle, as well as our successful practices in handling the foreign party-related cases. Some of the cases have been collected by the UNCITRAL, and on the 28th of October 2023, the Supreme Court also issued a very important document, and it is about interpretation of different international treaty or international related issues. And the Supreme Court stimulated how to choose the right law to apply to different cases for the purpose of adhering to the international treaties. As for the transferable or negotiable document, we have stick to our standing on our position all the time. So we need to have a very clearly defined international law so that we can comply with in handling with the negotiable or transferable document. This has always been our goal, and this is some of my personal observation in relation to the international treaty. So I look forward to in-depth discussions with you. Thank you very much.
谢谢欧法官 ，Thank you very much, Dr. O, for those clear and practical insights. Your perspective on the case, I understand that case from Chongqing Court, and China's contribution to the drafting process and the potential judicial approach after ratification provides a very valuable foundation for our discussion today. So now let's move to our second speaker. I would like to invite Professor Huang. You have floor. Yeah.
Hello, everyone. It's my great honor to present in front of distinguished audience and panels. Today, I would like to introduce the key features of this very new UN Convention on Negotiable Cargo Documents and its impact to the trade business in general, as well as to Korea. Starting with the background of this project, why is there a demand for NCD? First, there is a need for document of title. Unlike maritime transport, where there is BL, as for other modes, such as road, rail, or airway, and also for multimodal, the transport documents are not globally recognized as document of title. As you can see here in Article 7.4 of the Convention, NCD is a document of title because for the purpose of acquiring rights to the goods, transfer of the document has the same effect as physically handing over the goods. Document of title provides flexibility in international trade, as parties can buy and sell goods while in transit. And also it facilitates trade finance because the document of title provides better security for the banks. Second, NCD can give flexibility in complex global supply chain, especially in the multimodal context, since one document covers the whole journey. Based on circumstances, the transport operator can switch between different modes of transport while retaining the document of title function. Third, there's a need for a unified legal framework on electronic negotiable document. Because if there's a common legal standard on the recognition and the use of eNCD, It would give legal certainty, which will lead to facilitating digital trade. Now let's move to the key features. First, scope of application. Article 1.1 prescribes that the convention applies to the issuance, transfer, and legal effects of NCD that contains a conspicuous reference to this convention in connection with international transport of goods by one or more than one mode of transport. It does not regulate the rights and obligation of the parties to the underlying transport contract. The application of convention is not mandatory. It's an opt-in mechanism, so only when the parties have agreed to issue NCD under this convention, the convention applies. And such reference must be contained conspicuously on the document. It has to be issued in connection with international transport of goods, but it is not limited to specific mode of transport. It applies to all modes of transport, be it unimodal or multimodal, and also includes maritime leg, which means that the transport operator can issue an NCD in a carriage of goods wholly by sea. Article 1.1 also prescribes geographic scope. So in order for the convention to be applied, there needs to be at least one of these connecting factors, either place of taking charge of goods, or place of delivery of goods, or place of issuance of NCD. These are all, as indicated in the NCD, has to be located in a state party. Article 1.2, the convention does not affect any international convention or domestic laws regarding public law matters such as custom clearance. Article 1.3 deals with the dual-track approach. As we all know, there are other conventions such as Hague or Hague-Visby or Hamburg Rules or domestic laws which governs the underlying transport contract. The convention does not affect these existing liability regimes such as transport operators' liability for loss of goods. As for rights and liability, the convention only deals with those in relation to the holder of the NCD. Article 2.5 is the definition of NCD. NCD means a paper or electronic record which shows that it is medium neutral, signed and issued by the transport operator. Here, transport operator means that any person who concludes the transport contract with the consignor and assumes the responsibility for the contract. So it could be freight forwarder, maritime, rail, road, air carrier, etc. An NCD has to indicate by wording such as to order or negotiable or equivalent expression that the goods as specified in the document have been taken in charge by the transport operator and consigned to the holder, which means that NCD has to be an order document to make it negotiable. Article 3 prescribes the issuance of an NCD. There has to be an agreement between the transport operator and the consignor, which shows its voluntary nature on these three things. That is, first, whether to issue an NCD under the convention, and on the method. For example, by entering annotation on existing transport document, which is so-called upgrade method, or to issue a separate standalone NCD. And the parties have to also agree on the medium. NCD shall be issued when the goods are taken in charge by the transport operator, but if the parties agree, it may be issued at a later stage. Article 7 is rights of a holder under NCD. So upon issuance of NCD, the holder is the only one who can exercise rights provided for in the NCD, which shall include the right to demand delivery. The holder also acquires rights to bring a claim against the transport operator, right of disposal under the contract, for instance, changing the destination of the goods, and other rights under the law applicable to the transport contract, as if the holder were a party to that contract. The holder has to produce the NCD to exercise these rights. This is to protect the transport operator. Article 9 is about liability of a holder. If a holder does not exercise those rights, it does not assume any liability just because it is a holder. But if a holder exercises a right, it assumes liability that arises from the exercise of such right. For example, if a holder changed the destination and as a result incurred more cost, the holder could be responsible. Article 11 is about transfer of holder's rights. Holder can transfer the rights by endorsement to another person or blank and transferring the possession of the NCD, or if the last endorsement is in blank, by a mere transfer of possession. While the definition of NCD encompasses both paper and electronic, since some of the substantive provisions establish requirements that are traditionally associated with paper documents, therefore, Chapter 4 prescribes special conditions for eNCDs. The provisions are modeled after MELITA and ECC, and like those texts, this convention also applies a functional equivalence approach. In addition, the rules in Chapter 4 are technology neutral, so it is compatible with any system model. So the provisions in the convention are about reliable method, content requirements, signature, possession, endorsement requirement, and also it deals with how to change medium between paper and electronic, and general reliability standard. As I explained earlier, since maritime leg is included within the scope of the convention, during discussions there were various proposals to preserve existing regimes. For example, one proposal was to include a disconnection clause which excludes the application of this convention where a transport contract was governed by Rotterdam rules, and there were other proposals to allow general reservation or allow state parties to make declaration. In the end, the UNCITRAL decided to have a reservation clause as prescribed here. In essence, reservation is limited to unimodal maritime transport. And the convention enters into force after 10 states ratify. Finally, the impact of this convention. I have quite positive prospects. First, the convention fills the legal gap where there is no legal basis for issuing negotiable document of title, in particular multimodal transport. With this enhanced legal certainty, trade finance and international trade will be facilitated. Second, given the voluntary nature of the convention, it provides more option and flexibility to the market, which will promote party autonomy. Based on their needs, the parties are free to choose to take advantage of this new negotiable document. Third, there will be a globally uniform rule on electronic NCD. This will increase efficiency, mitigates risk, reduce cost, which will be a great support to the digital transformation in trade. Lastly, while having all these benefits at the same time, the convention leaves other existing conventions and domestic laws on transport unaffected, and therefore the conflict will be minimized. As for South Korea, I think there will be two main benefits. One is providing legal basis for issuing negotiable document in multimodal transport. While a significant portion of Korean trade is conducted by multimodal transport, in the Korean Commercial Act, with regards to multimodal transport, currently there is only one provision about the liability of the transport operator. If the convention applies, the multimodal transport operator can issue NCD covering the entire face of the carriage. The other benefit is enhancing the use of eNCD in maritime transport. Professor Song mentioned earlier in session 2 about our EBL provision in our Commercial Act. We do have one provision in our Commercial Act about EBL, but due to its limited method of issuance, which is making parties to register with the registry agency designated by the Minister of Justice, EBL is currently not frequently used. However, eNCD is technology neutral, so maritime transport operator may use eNCD as a good alternative. This concludes my presentation. Thank you very much for listening. Thank you.
Thank you, Professor Huynh, for your clear and comprehensive overview. Your analysis of the convention's key features, the legal gaps it will address, and the implication for Korea offers an important comparative perspective for our discussion today. Next, Edward, please.
Thank you, Dr. Yang, for your kind introduction, and good afternoon, distinguished guests, panelists, and ladies and gentlemen. It is really a great pleasure to join you today for this very important judicial summit and to participate in this afternoon discussion on the digital transformation of transport and trade. I speak here both as a practicing shipping lawyer as well as the principal representative of International Chamber of Shipping in China, which represents ship owners operating more than 80% of merchant tonnage in the world. For those of us actually in the maritime and trade community, digitalization is not an abstract concept. It is transforming how goods move, how contracts are executed, and most importantly for lawyers, how rights in cargo are transferred. But as I often remind my clients, technology alone cannot guarantee progress, but only technology combined with legal certainty can. So let's see from a broader significance of the convention that we are discussing today, which from both my and also global shipping industry's perspective, it is indeed a milestone in this direction. For decades, negotiability, i.e. the ability to transfer ownership through a document, was confined mainly to maritime transport, while the bill of lading, which we have already heard from many times since today. So other modes such as road, rail, and air used documents that serve as receipts or evidence of contracts but lacked this transferability. In approving this new convention in July 2025, UNCITRAL has effectively closed the historic legal gap, creating a single framework that could support truly end-to-end multimodal trade. This is an achievement worth celebrating, and it speaks to UNCITRAL's leadership in harmonizing international trade law and transport law. So, allow me to center my remarks on Chapter 4, which I consider the Convention's most transformative feature. Its specific recognition of electronic negotiable cargo documents, or ENCDs. This chapter gives commercial parties the choice to issue negotiable documents of title either in paper or electronic form, provided that certain reliability and control mechanisms are satisfied. In doing so, the Convention builds on the approach pioneered in the UNCITRAL Module Law on electronic transferable records, which have already been extensively discussed in Panel 2 this morning, while adapting it for multimodal logistics. What makes this so important is that digitalization is not simply a change of format, it is a change in legal architecture. Today, we actually already see the maritime sector actively adopting electronic bill of lading, supported by a growing range of digital platforms. This progress is reinforced by legislative reforms in key jurisdictions. Both the United Kingdom through its Electronic Trade Documents Act and Singapore through amendments to its Electronic Transactions Act have now given full legal recognition to electronic trade documents. The most importantly, which already heard from starting from the morning remark and also especially Professor Song Meixian, China has also taken a major step forward. The newly amended Maritime Law, or Maritime Code, which will take effect on 1st May 2026, introduces for the first time a dedicated section on electronic transportation records, including electronic bill of lading. Under the new provisions, electronic records that are complete, accurate, and verifiable will enjoy the same legal effect as their paper counterparts. They must be capable of identifying both the issuer and the holder, be readily retrievable for inspection, and by agreement, may even be converted between electronic and the paper form. This reform finally provides a clear statutory foundation for the use of the e-bill of ladings in China, which is an innovation that was previously supported only through industry practice and private digital systems. It reflects China's determination to align with global standards, promote digitalization, and enhance the efficiency and the sustainability of maritime operations. The NCD Convention builds on this global momentum, extending the same legal principle across all modes of transport and helping to create a coherent modern legal framework for truly paperless international trade. By confirming that the electronic negotiable document can have the same legal effect as its paper equivalent, Chapter 4 enables the trade participants to move forward paperless trade and the digital title transfer with confidence and uniformity, which is a crucial element for financial institutions, insurers, and logistic companies that rely on these documents every day. So what are the opportunities and, of course, challenges? From a practitioner's viewpoint, I think there are really three major opportunities and three legal challenges, maybe, that we will need to keep in mind as we move from drafting to real-world implementation. Let me start with the opportunities. First, efficiency and sustainability. Moving from paper to electronic negotiable documents can save both time and cost. No more waiting for courier deliveries. Digital verification can happen instantly, reducing the risk of loss or forgery, which are actually a headache for maritime transportation. And of course, it is good for the planet by cutting down millions of paper copies that currently move across borders every day. Second, financial inclusion. By creating a uniform global framework, the convention can open doors for smaller exporters and logistic operators, especially in developing and landlocked economics, to access trade finance and participate more easily in global supply chain. It puts them on the same legal footing as larger established players. And third, legal interoperability. The NCD Convention does not stand alone. When linked with the module law on electronic transferable records and the various e-commerce laws, it acts as the bridge that connects today's fragmented digital trade system, allowing true and untold paperless trade under clear, harmonized rules. So now turning to the challenges. First, also from the shipping industry standpoint, especially represented by the International Chamber of Shipping as well as the international group of P&I clubs, there's a clear recognition that the convention brings modernization and the clarity to global logistics. The global shipping industry do welcome the fact that the final text preserves the compatibility with the existing body of maritime law, including the Hague and Hague rules, by not disturbing established carrier liability regimes. At the same time, shipping practitioners emphasize the importance of ensuring consistency in jurisdiction and dispute resolution, particularly where multimodal contracts incorporate a sea lag. Hence, Article 24 of the Convention provides a useful safeguard, allowing states to make reservations that includes its application where carriage is wholly by sea and governed by another convention and can be strengthened further through implementing legislation, as mentioned, to ensure existing maritime regimes and the established body of Bill of Ladings laws will continue to apply whenever sea carriage is involved. So in short, for shipping community, we support the Convention's objectives while encouraging policymakers to implement it in a way that complements rather than displaces existing legal framework. So the legal certainty and dispute resolution in the digital age that we are all in. So as a lawyer, I find the most fascinating challenge not technical but legal. So how can courts and arbitrators interpret digital title documents with the same confidence as their paper equivalents? The convention gives us the framework, but the real-world certainty will depend on judicial interpretation. For example, how will courts approach conflicts between jurisdiction clauses in underlying transport contracts and the legal rights conferred by an NCD? How will they access authenticity or transfer of an electronic record when competing claims arise? UNCITRAL's approach, focusing narrowly on issuance, transfer, and legal effects, while preserving the underlying transport law, is a sound one from our perspective. It gives courts the tool to apply the new framework without rewriting long-established liability regimes. Yet capacity building, judicial training, and the sharing of cases law will be essential to make this work consistently across jurisdictions. So looking forward, if I may summarize, the new NCD Convention is a constructive and forward-looking instrument. Its electronic provisions in Chapter 4 sit at the very heart of the global digital transformation of trade. But exacts will depend on three things: legal certainty, technical reliability, and consistent adoption across jurisdictions. Looking ahead, the Convention gives us the chance to close the long-standing gap between maritime and non-maritime trade documentation. The challenge for all of us is to make sure that in closing that gap, we build a bridge, not a barrier, between long-established legal traditions and emerging digital innovation. Ultimately, the maritime industry and the legal community share the same goal as UNCITRAL: to strengthen trust, efficiency, and inclusivity in global trade and transport. If implemented with care and cooperation, the NCD Convention can become the foundation of a truly paperless, seamless, and predictable global logistics system. It represents not only a move towards digitalization, but a step toward a smarter, more resilient, and more connected future for international commerce. Thank you for your kind attention.
Thank you, Edward, for your perspective from the maritime industry, especially for the digitalization and the paperless transformation in your industry. And I also thank you mentioned the capacity building as a useful way to enhance the consistency in implementation of this convention in the future. So as one of the co-organizers today, our Hong Kong International Legal Tenants Training Academy welcome the capacity building program or opportunity with the UNCITRAL again for this coming convention in the future. And next, let's proceed for our fourth speaker, Ms. Pamela Ma. And Pamela give us a video, so I think the video is ready now. Thank you.
Hello, I'm Pamela Marr, and I'm here to talk to you about what the Multimodal Negotiable Cargo Documents Convention could mean for the digitalization of global trade. Now, some of you may know that the DSI has been leading a global campaign to drive the adoption of the model law on electronic transferable records globally, because we believe that this key legal reform could potentially unleash the digitalization of trade globally, because it enables documents of title to be negotiated and transferred in digital format. And if you go back just 2 years ago, countries accounting for 34.3% of global exports were either committed to or aligned to the MLETR. Based on a global campaign, which has involved chambers of commerce, policy advocacy, and other industry-focused tools, today that number is 61%. And we believe that given the policy background for MLETR, we will soon be over the line of basic critical mass. So if you look at major trading regions, everyone is committed to achieve this legal reform. Now, we view the NCD as a critical asset to this legal reform because it basically is a next step. It extends the same legal logic that underpins MLETR to all modes of transport: air, rail, and road, as well as, of course, sea, ensuring one harmonized framework for negotiable documents of title. Critically, what this means is that landlocked countries, for example, those with the need to import, for example, by sea and then transfer onto road or train, these can be the cargo can be handled with one single document as opposed to 2 or 3, as is the case today. And as a convention, the NCD will also make aligning to this legal framework potentially easier because countries won't need to actually undertake legal reform, which is a lengthy process that could take anywhere from 1.5 to 3 years or longer. Rather, when they ratify it, when they sign it and ratify it, it actually becomes accessible and legal for the business community, which is a critical aspect on why business may hesitate to move forward. Well, our view is that the NCD is actually highly complementary to MLETR, same principle of functional equivalency. It doesn't really change anything about how the parties are using the document. The only thing that changes is that it could be in electronic form, and it carries all the advantages of what digitalization does in terms of security, tagging, traceability, speed, efficiency, lowering costs, and so on. So from our perspective, and you saw on the previous slide the MLETR tracker, our view is that once a country will align or sign the Negotiable Cargo Documents Convention, they are automatically aligned to MLETR. So this is a highly positive development that we obviously support globally. Now, the additional thing is that the NCD could potentially be a real asset in unlocking trade finance by allowing cargo to actually be transferred even before it arrives at the destination, and that will unlock payment. So banks can more easily and readily accept multimodal documents as collateral. Title can be transferred faster and more securely using reliable systems, and SMEs in manufacturing and logistics could gain access to working capital more easily. Why? Because if it's cheaper and easier and just as secure for banks to transact based on that cargo, they're more likely to be willing to do shipments of smaller size or for smaller players who might lack the normal collateral which banks require in order to grant financing. So this critical kind of digital convention could actually be the key to giving SMEs more financing than they currently have access to. We also think, as I said, that landlocked countries will be particular beneficiaries of the Negotiable Cargo Documents Convention. For any of you who have been studying development, basically LLDCs have a particularly hard time engaging in global trade. And if you accept, I guess, the wisdom that trade is a way to move up the development ladder, that poor countries that attach themselves to global trade can more easily create jobs, generate growth, and therefore take charge of their development. So for landlocked countries, their access to global trade is more limited because they don't have a port, they don't have easy access to transit links, and in order to trade globally, they usually have to pass through 1 or 2 or even more other countries, all of which add stopping points, bottlenecks to their trade, to their trading journey. And as a result, it's well documented, LLDCs actually have a lower growth, higher trading costs, and you can see the figures here that they're 7% of global population, but only 1 or 2% of global trade. So we're looking for ways to basically unlock the potential of these trading nations, and there's 32 of them. You can see them on the map, and basically, we believe that if they sign the Negotiable Cargo Documents Convention, they can more fluidly access global trade links. So there's the financing aspect, which was on the previous slide. Then there's this key development aspect, which basically enables the poorest countries in the world, the ones with the highest trade costs, with the most difficult trading journeys, to basically, it's another tool in their toolbox in order to access global trade. Now, the other aspect is the role of China. Now, China is an example of a country that has both coastal regions, but also does a lot of inland trade. And so to the extent that for landlocked countries that trade with China, they can actually hitch themselves to the Chinese development engine at the same time. So there's a huge potential for landlocked countries to basically become greater beneficiaries of global trade. Now, I also have to make the point that for all of its potential benefits, the NCD, the Negotiable Cargo Documents Convention, is not the answer to all of them. You know, basically, this is a great asset to the project of legal reform and policy reform, which will enable the digitalization of global trade. But we should also keep in mind that legal infrastructure is necessary, but not sufficient on its own. There are also technical aspects to be mastered in digitalizing trade, and by this I mean standards, so the adoption of globally interoperable standards, the adoption of different trust mechanisms, which will allow the negotiable documents to actually be transferred in a way that meets reliability and other conditions. And then there's, of course, the human aspect, which is really essential because people don't like change, and any change will require the appropriate capacity building and the appropriate support to ensure that we bring the employees and bring the people along in the task of digitalization. So these are areas that DSI works on. And just to share with you a bit about what we have learned about the digitalization of other trade documents through MLETR and other means, is that there's no question that the proof of value of digitalization is very clear. All we're saying is that now that we have this evidence, let's scale it. Let's make it available to as many countries and businesses as possible so that they can access some of the gains which you see on this slide. So that's all I have, and thank you very much. And if any of you have any questions or comments about any of this content, we'd be delighted to hear from you. Thank you very much.
Thank you, Pamela, for your thoughtful and forward-looking observations. So now let's move to our last, but of course not the least speaker, Yan-Ying Li. And for our final presentation of today's this session, Yan-Ying is from UNCITRAL Vienna right now, and she will be speaking virtually. Yan-Ying, please.
Thank you. Good afternoon, distinguished judges, colleagues, and greetings from Vienna. Thank you for the opportunity to join today's discussion on the relevance of the NCD Convention for Digital Transformation. You've already heard a very comprehensive overview of the NCD Convention from the previous speakers, and I will just add an update on its current status and some comments on electronic NCDs and the related pilot project. The draft NCD Convention was finalized and approved by the UNCITRAL Commission during its annual session in July. It is currently under consideration by the UN General Assembly. We have been informed that the deliberations within the 6th Committee in New York have proceeded very smoothly, and the Convention is expected to be adopted by the General Assembly in the coming weeks. And around mid-December, the working group that developed the draft NCD Convention is scheduled to meet again, and probably for the last time, to review the draft explanatory note on the NCD Convention. From the outset, the NCD Convention was prepared with a view to accommodating NCDs issued in paper and electronic form. As you've heard from the previous speakers, Chapter 4 is modeled on the provisions of the UNCITRAL Model Law on Electronic Transferable Records, MELITA, and follows a functional equivalence approach, which prescribes the conditions by which the functions of formal requirements traditionally associated with dealings in paper documents can be fulfilled by the use of electronic means. The rules in Chapter 4 are intended to be consistent with the provisions of MELITA, and as a result, it is expected that the systems and methods used to support electronic transferable records in compliance with the functional equivalence rules in MELITA can be used to support the use of electronic NCDs in compliance with Chapter 4. During the July session, the Commission considered a proposal to include a provision clarifying that the Convention does not require any person to use an electronic NCD without their consent, mirroring Article 7.2 of MELITA. After extensive discussion, however, the Commission ultimately decided not to incorporate such a provision. And this raises practical questions. For example, if the seller arranges transportation and agrees with the carrier that an electronic NCDs will be issued, what happens if the buyer prefers to receive a paper NCD? Would the buyer have a right to request the carrier to convert an electronic NCD into a paper form? Under the Convention, no such unilateral right exists. Any change in the medium, from paper to electronic or from electronic to paper, must be mutually agreed between the NCD holder and the transport operator. And this feature of the Convention may, in effect, accelerate the shift towards digital trade, as future buyers may find themselves obliged to accept electronic NCDs when those are chosen by the contracting parties early in the chain. While this creates opportunities for digitalization, it may also pose implementation challenges. A key concern is the readiness of all parties in the supply chain. What happens when some buyers are simply not prepared or technologically equipped to operate in a fully digital environment? Addressing such discrepancies in digital capacity will likely become an important part of the Convention's practical rollout. Now you may wonder, how does an NCD look like? Here I have some examples. Since July 2024, Chinese importers have benefited from 4 pilot projects involving wheat flour being transported by rail and road. Importers were able to access finance from the Bank of China using an NCD issued by freight forwarders. And NCDs, like Marine Bill of Lading, can be used as a credit enhancement tool, and banks can become an endorsee of an NCD and exercise rights of a holder, including demanding delivery of the goods in case the buyer or the importer fails to repay. And the banks can also become a secured creditor through pledging an NCD, creating security right over the goods represented by an NCD. But banks couldn't do any of these with a rail consignment note, as you've heard from Judge O earlier in the example. And in these pilots, the importer, freight forwarders, and the bank had to enter into a tripartite agreement, which contractually recognized the NCD as the only document that must be surrendered when demanding delivery of the goods. However, if the Convention on NCDs is formally adopted, this additional agreement would not be necessary. And these pilot projects demonstrated tangible benefits of innovative solutions like NCDs and their potential to unlock new opportunities. On the screen, you can see the electronic example of electronic NCDs issued in the form of annotated FIATA multimodal bill of lading. And this is an NCD issued by a freight forwarder registered in Switzerland for the transportation of fertilizers from Garabogas, Turkmenistan to Castananta, Romania, involving maritime, rail, and road transport. It serves as an example of a single electronic NCD covering door-to-door transportation. And on the bottom of the slide, you will see the annotation with reference to the UN Convention on Negotiable Cargo Documents. It is envisaged in the convention that the parties may agree on any method to issue NCDs, as Professor Huong has already elaborated in her very comprehensive overview of the key features of the convention. And in Article 3 of the convention, there are two examples of how NCDs can be issued. One is through inserting an annotation in the existing transport document. And the second is a standalone, a new NCD as a new document. And the first example was agreed upon, many not with the thinking that not to interrupt the current market practice, so that it becomes very easy for businesses, if they want to use an NCD to benefit from this new legal framework, they could simply do so by issuing the same document they issue today and insert annotation which refers to the convention, as long as the new document could meet the definition of the NCD. So this criteria is quite straightforward, as you can see in these pilot projects showing on the screen, is essentially taking the current, the document already existing in the market. It's a FIATA's multimodal transport bill of lading. But because there is a lack of international legal framework to support the negotiability of such a document, the annotation itself would bring the document into the NCD regime and to enjoy all the benefits provided by this regime. And at the same time, they could they do not need to change much the current document as it already meets the definition of NCD. It has it's an order document, and it has the most of the requirements already there. The convention will enter into force 118 days after being adopted and ratified by 10 states, and this will bring NCDs to the market. Electronic NCDs can also benefit from the legal framework, provided the collectors in Article 1 are met. And there are three of them. That is, one, the place of taking charge of the goods is located in a state party to the convention. And two, the place of delivery, as indicated in the NCD, is located in a state party to the convention. And third, the place of issuance of the NCD, as indicated in the NCD, is also located in a state party, and the connector is all. So that's as long as any of the criteria is met, the convention can apply. And one interesting element raises with the third collector, because it's referred to the place of issuance of NCDs as indicated in the NCD. And the reference to as indicated in the NCD was added mainly to help the current situation in the context of electronic bill of lading, where in most jurisdictions there is no law or guidance yet on how to determine the place of issuance of electronic bill of lading. And if it may require a lot of analysis or even potentially looking into the place of business of the issuer. And the wording in the convention itself chose a very simple one, as referring to the place of issuance as indicated in the NCD, and which we understood is also reflecting the same result of a court decision in Australia couple of years ago concerning the same issue about the place of issuance of electronic NCD. Now I would like to pose a short question. Assuming that China becomes a state party and the place of taking charge for exports is located in China, the place of taking charge, and the electronic NCD would be governed by Chinese law. And this raises the question for our distinguished judges. So would such an electronic NCD be recognized and giving effect in jurisdictions that are not yet state parties to the convention? And notably, Article 1 of the NCD Convention does not require judges to determine the actual place of issuance of electronic NCDs, a task that can be highly complex, and given that NCDs are documents of title. So instead, Article 1 refers simply to the place of issuance as indicated in the NCD. Then the second question is, would the parties be permitted to insert a place of issuance that bears no connection to the underlying transactions? Some food for the thought, and thank you for your attention.
Thank you, Yang. For your last questions, I would encourage all the judges are here today to think about that. And I will maybe later ask Oh Hai-Yan later, because for today's session, we have a very broad range of perspectives on the NCD, from judiciary and academic and to industry practice and the latest development from UNCITRAL from Yang. I believe today's discussion, the presentations have provided a very rich foundation for understanding both in the opportunities and the future surrounding the NCD. So now, according to my understanding, we have around 14 minutes for Q&A. And actually, I already got a number of questions on my iPad. So Yan, if I may, I would post those questions from audience first, and then to see whether your questions just posed, the other judges would like to answer. The first question I would like to ask Judge O. There is a question related to the China's Maritime Code. So the question is that given the revision of China's Maritime Code, have you seen an increase in adoption of e-bills of lading in practice? And are there still challenges in adoption? What is your view about the NCD and the bill of lading?
Thank you. Very good question. And I'd like to give some personal observation. In fact, e-trade is a trend, and China's Maritime Code has adapted to the trend. So e-bill of lading is the effect of e-bill of lading has been recognized by the code. So in practice, if there is some obstacles for e-bill of lading, I think it's not the law, it's a technical reliability. So that's a main factor will influence the use of e-bill of lading. And to another question, will NCD affect bill of lading? It's really a very good question. I'd like to give my remark on this issue, because what we proposed is to solve the problems of the lack of a document of title in the railway multimodal transport. And the creation of NCD under convention is to provide sufficient instruments or enrich the legal box for the transactions. So the Article 1 of the convention, the scope of application specifically stipulates that this convention does not affect any international convention or domestic law regulating or governing transport operations. And this convention is not mandatory, it's chosen by parties to apply. So if the market use NCD, that indicates the market need it. And if not, this document will naturally be set aside. So the maritime market should have confidence in a bill of lading because the NCD started as emulating the bill of lading. It itself a tribute to the bill of lading. And in these two is consistent in legal logic. And in fact, a bill of lading could be transformed into NCD by adding a notation subject to NCD convention. And from another perspective, the market is evolving. And currently, the global trade transport has developed from a segregated single modes of transport into integrated multimodal transport, even to global supply chains. And the market, the bill of lading can only be used in the maritime shipping and cannot meet the needs of multimodal transport market. So just back to my starting point, what's the most important thing is how effective the instrument is for the market. So I think these two, there is no shock, there is no effect. There will be a cooperation in harmony in the future. That's my point. Thank you.
Thank you, Dr. O. Next question I would like to ask Professor Huynh. The question is that if a country adopts the NCD convention, does that mean that country don't need to adopt MLETR and MLWR, as these documents are all covered by NCD?
Thank you for the question. Maybe I'll try to answer as far as I know, because I am not exactly the expert on the MLETA. In my opinion, I think although the NCD captures a lot of part of the MLETR also has its own area covering the larger part of the electronic transfer of a record. So I don't exactly think that it's unnecessary to adopt the model law, but as far as we are speaking about the negotiable cargo document and the electronic version of negotiable cargo document, I think the convention pretty much covers what we need in order to operate an electronic negotiable cargo document. Hope that's...
Ying, do you want to add something?
Yes, and thank you very much. And as Professor Huynh already pointed out, MOETR is much broader in scope. It's a model law for all types of transferable records. It includes bill of lading, but also includes many other types, such as promissory notes, warehouse receipts, and any others that under the domestic law is qualified as transferable records. So the scope is very different from the scope of the NCD convention. And for the NCD convention, it only governs this document, most relevant only in the transport area. And if we were to comparing let's say if we are talking only about digitalization of bill of lading, if you adopt the NCD convention, do you still need the MOETR? The answer is if you adopt the NCD convention only for the purpose of to use electronic NCDs, including in the form of annotated bill of lading, then you may not need to adopt Melita just for this purpose. Because statistically speaking, if for UNCITRAL Secretariat, once a country becomes a state party to the NCD, it will also be reflected as a Melita jurisdiction on the UNCITRAL's statistics, because the substance is exactly the same. It could be even, with adopting the convention, the countries have very few freedoms to deviate. So in substance, a Melita compliant jurisdiction may look even less like the Melita text compared with the NCD jurisdiction, because of the fact that countries adopting model law are free to adapt it to their domestic context. And because of this feature, that once a country is adopted NCD, it will be counted statistically as a Melita jurisdiction for the context of the transport document. And also, as we heard from Pamela's presentation, from the ICC DSI standpoint of view, their statistics will also reflect this for the Melita tracker. However, the scope, as I mentioned, is very narrow, and what ICC DSR has been working very hard in the past few years, I understand, is to move digital trade, to expand it to all areas. So the goal is not just the digitalization of transport documents, or that's what the main focus of the NCD convention, but to expand it to all types. And for that, countries must adopt the MLTR. And in your question, and I think you also mentioned MLWR, the model law on warehouse receipts. And the model law on warehouse receipts actually is quite similar to the NCD in a way that it's a substantive law instrument. It covers the paper and electronic version of the warehouse receipts, and the provisions on the electronic version of warehouse receipts are also based on Melita, MOETR, as warehouse receipts is also a type of transferable records. And for the model law on warehouse receipts, as it contains also substantive law provisions, it's suitable for jurisdictions who would need rules not only to digitize warehouse receipts, but also to improve or to develop more substantive law. So that's the key differences, that whether you are looking to adopt the model law on warehouse receipts or Melita, or in the context of the convention, that if the need you are focusing on is only digitalization of negotiable cargo documents, and then this convention would be the most suitable, the narrow scope for that purpose. I hope this clarifies.
Thank you, Yan. This is very clear. So last question I would like to ask Edward. There's a question from one of the audience. The question is that what unique value can Hong Kong offer to the development and the operation of the new framework?
Thank you, Dr. Yang. Well, as I mentioned, that from a shipping perspective, I would like to thank actually the platform to give me this opportunity, because shipping is quite unique. And when talking about the multimodal transportation, shipping is always thinking that we are special to the other models because we have already the bill of lading in practice. And therefore, that actually, when preparing this speech note and together after I heard all the speeches from our panelists, I've learned a lot. I think that is really the opportunity actually for the shipping industry to be more inclusive and to be adapted into the multimodal instead of only thinking ourselves. And more importantly, I think, returning to Dr. Yang, your question, and as a lawyer, I think that what we can provide, first is that definitely when a new convention comes into effect, whether you like it or not, it will bring the new legal uncertainties. Because as already mentioned, and people already mentioned, that it requires the the industry's familiarization of the convention. It requires the different courts to interpret the relevant provisions. Not to say even for domestic law, but like the UNCITRAL conventions, it requires the unification of the judicial interpretation. So definitely, I could see that Hong Kong can definitely play the vital role because we are the super connector of the West and the East, and we are most importantly we are of course a common law jurisdiction, but together with the mainland China, we bridge the gap between the common law and the civil law. And for every international convention, the most important thing is not only for the industry and different courts, domestic courts, to accept it and to interpret it. It also, more importantly, for different countries, different legal systems to understand it and to provide the best practice for the industry to follow. So I think that for Hong Kong, we definitely see these opportunities, and especially for more multimodal disputes to come, and then to choose Hong Kong as arbitration venue and the court resolution venue. Yeah, thank you.
Thank you, Edward. I'm cautious about time. So for the two questions again imposed at the end of your presentation, I would encourage all the judges today to think about that and trying to answer those two questions in your future practice in your prospective jurisdictions. So this concludes our third session of today. So many thanks again for all the panelists. And yeah, thank you.
Thank you very much. Can I please invite everyone to remain seated as we'll take a photo before sending everyone back off to their seats. And thank you to all of our panelists and of course, Dr. Yang for being our moderator. Thank you very much. Everyone, thank you once again and please be seated. Thank you for all the exchanges and all the insightful discussions. Everyone, we will now take a 15-minute break. Refreshments are available, that is outside the hall. Please take your valuables with you when you leave. And also for online participants, please stay logged in. Our next panel session will begin at 4:15 p.m. Thank you very much. Ladies and gentlemen, welcome back. The last panel of today's conference will focus on current trends of dispute resolution in the digital economy, which will be moderated by Ms. Judith Knieper. She's right beside me. Thank you very much for being with us. She's the legal officer of UNCITRAL. In joining Ms. Knieper are three panelists. We have Ms. Joanne Lau, Dr. James Ding, and Professor Teresa Rodriguez de la Harris Barral. Thank you very much for being with us today. There will also be a Q&A session at the end of the panel discussion today, where you can scan the QR code on the screens to submit your questions. And we just want to say thank you very much for joining, and I will hand the time over to all of you.
Thank you very much indeed. And maybe before we start, let me join my colleagues in expressing our condolences to the people of Hong Kong, and especially our thoughts, especially with the victims and their families. If I could have my presentation, I am having a double role somehow. I'm not only the moderator, but I have to quickly introduce the topic that brings us here today, which is a project called Dispute Resolution in the Digital Economy. And this is a project we started in 21, of course, triggered by the pandemic. we were all in the very same situation that we had to communicate online, we had to communicate remotely, and this is when the Commission came up with the idea to work more systematically on this issue, and we had the government of Japan who generously contributed to funds to the project so that we could really run it since 2021. And the idea was to take stock of what is out there and then to analyze the aspects of digitalization from the perspective of due process, of fairness, and also highlighting the positive aspects of digitalization, which is cost and duration. Now, 4 years later, we are we all learned a lot, but often obviously not sufficient, so that I'm pressing the wrong button. But what we tried to do is initiate a world tour where we went to the different geographical areas to find out what the problems are, what the issues are, and mapping the issues. And one big issue that we faced was what is currently handled by Working Group 2, that there was no reliance on awards in electronic form. And we noticed that this was a big way of, or that was a useful way of really cutting down the duration of an arbitral proceeding by enabling the use of electronic awards, and this is what the Working Group 2 is currently focusing on. We also had different topics on the agenda, and we got the mandate from the Commission to further explore, and this is what we are also doing today. You see here video conferencing in arbitration and mediation, use of AI in dispute resolution, and dispute resolution platforms. So here you see what we hope to achieve with Working Group 2, that you can rely on electronic awards. I'm not really sure where I have to hold the clicker. It's not properly working. I thought we have learned a lot. We have not, obviously. So here you see the text we are currently looking at in Working Group 2. So we are looking at a recommendation to the New York Convention. We are looking at changing or tweaking a bit the text of the model law on international commercial arbitration. And we are also looking at tweaking the arbitration rules and the explanatory texts. So at the Commission session in 25, we had a paper in front of the Commission on the use of AI in dispute resolution. And we had a submission by Israel on remote arbitration hearings and mediations. And we had a submission by the IGLIB project on platform-based dispute resolution. So these are the 3 topics that remain in this DRDE project, and these are the 3 topics that we are also going to explore today. I'm aware that we have mainly judiciary in the room today, and while we are focusing on our text, which is alternative dispute resolution, we are still very much in need of the judiciary. Alternative dispute resolution would not function if we would not have the judiciary, which is enabling the use of alternative dispute resolution methods. So I'm very happy that we can have these discussions also with the judiciary, because the judiciary indeed is key to what we do. So here you see the different use cases of AI in arbitration. And what we identified, and I'm happy that Teresa is then taking on that topic, is what are the critical issues if you use AI. And what we identified as a main topic is whenever it impacts the recognition and enforcement of arbitral awards. This is something we want to look at, and this is how we framed the use of AI in dispute resolution. So really seeing when does it have an impact on recognition and enforcement. The submission by the government of Israel was to first acknowledge that we all learned a lot, except myself, obviously, when clicking the right button. But generally speaking, we learned a lot on how to use remote hearings. I remember in the past, before we had a remote session, we had around 3-4 meetings to try the system and to see whether everyone was able to do it. And somehow the remark by Adam today to see, do you hear me? That was the sentence of the year in 21, I guess. And you never got an answer because people didn't hear you. So that was the question that was always posed and never responded to. Now everyone is really able to use these instruments quite properly. And then we have, and James is going to talk on this issue, the IGLIP project, where we try to define or to look at the issue of dispute, platform-based dispute resolution services. So here you see the mandate of the Commission we were given this year. So whatever we are discussing today is immediately feeding into the work of the Commission. So you are part now of UNCITRAL's exploratory work, and we are very grateful for that. That's why whatever idea you might have, whatever comment you might have, if you have no time to let us know today, just ask us or tell us later. We will include whatever idea comes. It doesn't matter whether it's in a formal setting or whether it's informally. We will take everything on board, and we will be grateful for every idea. So with that, I turn to my 3 speakers we discussed beforehand that I don't really need to present them, because first you have their bios on the program, but more importantly, you all know them. So I don't really know what I could say in addition. So maybe just that Ms. Joan Lau, the General Secretary of the Hong Kong International Arbitration Center, with extensive experience also in private practice, is going to present us with the question on remote hearings in arbitration, and also a bit on mediation. Then Dr. James Ding, who is the law officer of the Department of Justice, which he joined already in '99, and heads the International Law Division, is going to speak on the IGLIP project. And maybe we should have done his presentation after tomorrow, because tomorrow we have an expert group meeting, which will maybe change a bit the setting. And last but not least, we have Teresa Rodriguez de las Heras Balel, who is, as you know, full-time professor of commercial law at the Universidad Carlos III of Madrid, and currently also the president of the European Law Institute. And with that, I would like to give the floor to Joanna to introduce us to the very first topic on remote arbitration and mediation.
Hello, everyone. It's my privilege to see you all here. Let me get the clicker. Thank you. So just by way of introduction first, I am the Secretary General of the Hong Kong International Arbitration Center. Hopefully many of you are familiar with our center, but for those who are not, the HKIAC has been set up in Hong Kong for 40 years now. This year is our 40-year mark. So we have had a lot of experience in administering arbitrations and assisting parties with, say, appointing mediators in Hong Kong. So I think that provides us with quite a good vantage point in looking at how hearings are conducted. I think not all institutions are the same, but for HKIAC, in addition to administering disputes, we also provide premises and facilities for parties to hold hearings. So that's why we also have some observations based on parties' usage of virtual hearings. So I thought I would start the presentation in just sharing some statistics that we've been seeing. So if you look back to year 2019, so that is before the entire pandemic, we had no virtual hearings at all. So in 2019, 0 virtual hearings. But if you look at during the pandemic and post-pandemic, HKIAC has since held 347 partial and fully virtual hearings. So I think that is quite a drastic difference if you compare pre and post pandemic. And what do we mean by partial and fully virtual? If we say partial virtual hearings, that could also be described as hybrid hearings. So some of the participants to the hearing would be joining in person, whereas some participants would be joining online. So what we often see is, for example, during the pandemic, the presiding arbitrator would appear in person with the 2 co-arbitrators dialing in from elsewhere. Or you may see some witnesses appearing in person to be cross-examined in person and others dialing in virtually. For HKIAC, because we have offices in Hong Kong, Beijing, Seoul, and Shanghai, we've also seen partial virtual hearings where some participants join in person in our Hong Kong premises and some witnesses join virtually from our Beijing premises. So those are partial virtual hearings. For fully virtual hearings, mostly seen, I think, when there was a complete lockdown or when the hearing is very short. Fully virtual hearings mean everyone is online. You might not see anyone meeting in person, but everyone just joining virtually. So even though there is a big difference between pre-pandemic and post-pandemic, if you look at the trend post-pandemic, I think that is also really interesting, because in year 2022, when we emerged from the pandemic, we hosted 93 hearings that year, and 81% of those hearings were fully or partially virtual. So you see the blue. In 2023, HKIAC hosted 101 hearings, but that 81% figure has dropped to 44% virtual hearing. In 2024, we hosted 122 hearings and only 39% were virtual hearings. So I think both based on these numbers, but also just based on anecdotal observations and our day-to-day observations, parties are actually switching back to in-person hearings, particularly when it comes to merits hearing, which lasts 4 days. However, I still believe that virtual hearings, particularly in the hybrid form, partial virtual hearings, are here to stay. So we're not going to go back to pre-pandemic where we have 0 virtual hearings. I think for, say, 1-day procedural hearing or for smaller value cases, parties are still finding virtual hearings or the option to go virtual extremely helpful. So looking at the procedural framework, in a way one could say that virtual hearings are nothing special in that the framework of many jurisdictions, many institutions have provided for it all along. So using HKIAC as an example, back in 2008, 2013, before we even address the use of technology, in our rules it's already very clear that tribunals, parties, they need to do everything necessary to ensure fair and efficient conduct of an arbitration. So if, for example, the use of virtual hearings can help with the fairness and efficiency of proceedings, one could say tribunals ought to be considering that. In 2018, this was the first time when HKIAC made explicit reference to the effective use of technology. So that is even a stronger case that if through virtual conferencing technology, you can assist with the conduct of arbitration proceedings, that ought to be considered. In our latest revision of our rules in year 2024, we also recognize that there could be some risks which come with use of tech in arbitration proceedings. So that's why we made very express reference as well to information security when conducting proceedings. And if you look at our rules on manner of hearing, and I think that differs from institution to institution, but using HKIAC as an example, there's actually no express reference either that a tribunal must conduct a hearing, let alone mandating tribunals that all hearings must take place in person. So there is a lot of discretion given to an arbitral tribunal in how they wish to manage proceedings. That said, actually at the start of the pandemic, there were in fact some cases where the use of virtual hearings were controversial, and I've given an example here on this slide, the Sky Power Construction Engineering case. I think it was quite an interesting one. So in that case, the respondent argued that because the hearing was conducted entirely virtually, such that, for example, the claimant's witness only testified virtually. So the respondent argued, oh, well, I cannot see the witness in person, I cannot observe their demeanor, I cannot test the authenticity of their evidence. So they were challenging the enforcement of an award on the basis that they could not adequately present their case. But in that judgment, the Hong Kong court denied that as a ground for refusal of enforcement. Of course, every case still depends on the seat of arbitration and the applicable procedural rules, but in that case, the court did recognize that having examined the procedural framework, the tribunal has the discretion to manage the proceedings. They need to ensure that the proceedings are fair, but they also have a duty to proceed expeditiously, need to avoid unreasonable delay. So in ordering that the hearing should be conducted virtually, that wasn't sufficient ground to refuse enforcement. And I've included a quote on this slide because I think that's quite a nice observation and a quite good summary as well, in that remote hearings are now commonplace in court proceedings as well as in arbitrations. And I haven't really covered like mediation so far because for HKIAC we don't have, I think, a big enough sample size yet to show the figures that we have for arbitrations. I think for mediations there are some virtual participation, but in a way I might even say for mediation having that in-person interactions might even be more important than in the case for arbitration, which is ultimately an adversarial process. Do I still have 2 minutes? So just to wrap up, for HKIAC, we've also published procedural guidance. At the start of the pandemic, we released what's known as the virtual hearing guidelines. So we provided tips for parties, and these are available on our website, addressing things like for video conferencing, you need IP encryption. How do you ensure confidentiality and security of virtual hearings? If you have witnesses, consider the use of hearing invigilators, 360-degree viewing cameras. All these are important safeguards. We also published FAQs, frequently asked questions on virtual hearings to guide parties. But I must say, based on our interactions with counsel and parties, they are getting so much better these days in understanding the do's and don'ts in virtual hearings. The final slide is really just some food for thought, and I know Teresa is going to cover AI, so I won't steal the thunder, but I think the point that I wish to make is there are some procedural guidelines now, but I think with emerging technologies, there will also be emerging threats and risks, including, say, for example, DeepSeek. How do you ensure that witness testimony received through video can be trusted? So I will just leave it at that, and I'll leave it to other speakers to address this more. Thank you.
Thank you very much for this comprehensive overview. I just have a follow-up question. Do you see room, or would it help if UNCITRAL would take up work in the area of remote hearings? Or do you say that we are all so savvy nowadays that we don't really need additional guidance? If something should be regulated, it's more in the area of artificial intelligence, which is posing more challenges.
I think there is still some benefit in at least considering whether it needs any guidance. To give an example, the PRC recently released its new arbitration law, and in there, interestingly, there was a provision addressing remote hearings, saying online hearings are allowed, but there was a caveat saying unless one of the parties disagree. So that's one approach taken by one jurisdiction, but I mean for other jurisdictions, maybe they might have different considerations, like even say if one party disagrees, can there still be online hearings, and should there be a more uniform approach across different jurisdictions? I think that could be a question that's worth thinking about more.
Maybe I have one additional question, and that is, you mentioned the hybrid setting. Is there a risk of the proceedings becoming unfair if one party is there in person, the arbitrator as well, and the other party joins virtually? Is there an issue with equal treatment between the parties, or at least the perceived risk of having such an unfair treatment? And is that something that should be taken up by an organization like UNCITRAL?
I think potentially there could be a perception of unequal treatment. So say, for example, parties might accept that the presiding arbitrator joins in person, whereas the two co-arbitrators join virtually, but they might not accept that one co-arbitrator joins in person, but one co-arbitrator joins virtually. And likewise, I think for witnesses, which is why I think even if it's technically possible under procedural frameworks, or tribunals would have to consult with the parties first and to take into account the principle of equal treatment in devising suitable procedures. But as to the next question as to whether UNCITRAL needs to provide guidance on that, I think a line needs to be drawn in that. Because arbitration is such a flexible procedure, we also need to be careful not to be overly prescriptive and to ensure that tribunals still have the flexibility to really find the most suitable procedures, taking into account the specific circumstances of each case.
Thank you very much. And when we discussed how to organize our panel, we decided to be from the least revolutionary topic that we all know about to what is more and more revolutionary. So that's why we would have James as with the second topic, which is dispute resolution in online platforms. Thank you so much.
Thank you, Judith. Before I talk about the argument on ODL that Judith just mentioned at the beginning of the sessions, I would like to give you some background about ODR, online dispute resolutions. ODR is nothing new, and back in 2011, UNCITRAL has already started some work in the area of online dispute resolutions. And they observed that there's a lack of effective methods for resolving cross-border commercial disputes, and there's a need to identify mechanism for resolving disputes arising from cross-border online transactions in particular. So they proposed that ODR, online dispute resolutions, is one of the options to help the business involved in the cross-border commercial disputes. And as a result of their work, the UNCITRAL technical notes on ODR was adopted in 2016. And the General Assembly of the UN observed that ODR can assist the parties in resolving the disputes in a simple, fast, flexible, and secure manner without the need for physical presence at meeting or hearing, and recommend all states and stakeholders to use technical notes in designing and implementing ODR systems for cross-border commercial transactions. I'm not going to go into the details about the technical notes, but basically it's a document designed to contribute to the development of ODR systems to enable dispute settlements arising from cross-border, in particular low-value sales or services contract concluded using electronic communications. So it just provides some descriptive, non-binding general principle of fairness, transparency, due process, and accountability. It aims to help states to developing ODR systems that are accessible to buyers and sellers in countries at all levels of development. And this technical notes covers both B2B, business to business, and B2C, business to consumer transactions. It outlines 3 stages, including negotiations, facilitated settlements, the mediation stage, and a final stage, which is not specified in the technical note. So with this UNCITRAL technical notes in the background, APEC, the Asia Pacific Economic Cooperation, is also working in the area of ODR. Some of you may know that MSME, the micro, small, and medium-sized enterprise, account for over 97% of all businesses in APEC economies. And the APEC Business Advisory Council, the APEC, which Margie represents at the presentation this morning, also has conducted a study saying that as many as 94% of MSMEs consider dispute resolutions one of the greatest challenges in conducting cross-border trade. So effective ODR tools are critical for handling complaints and disputes in the digital marketplace. So the APEC Economic Committee has launched and developed a project to explore the use of ODR to assist MSME to resolve cross-border disputes, enhancing their business recovery and facilitating cross-border trade. In 2019, the APEC Economic Committee endorsed the APEC Collaborative Framework for ODR of cross-border B2B disputes and model procedural rules. Due to the interruption by the pandemic, the framework is only implemented or officially launched in 2022. And currently, one-third of the APEC economies have already opted into the framework, and there are ODR providers listed under the framework, and with more coming. So what we have done at the APEC is we make reference to the UNCITRAL technical notes, in particular sessions 7, session 8, and session 9. And we also have 3 stages under the framework. That's negotiations, mediations, and we specify the final stage, that's arbitrations. And to my understanding, the APEC ODR framework is probably the first and maybe currently the only ODR framework model on the UNCITRAL technical notes on ODRs. And the framework also makes reference to other UNCITRAL texts that are considered useful for the implementation of the framework. We make reference to the New York Conventions, the UNCITRAL Model Law, International Commercial Arbitrations, the Electronic Communications Conventions, and the Model Law, as well as the Singapore Conventions. And we are still in the progress of implementing the framework, and just in October this year, the APEC Structural Reform Minister recognized the value of the framework and encouraged the continuations. And there will be a review coming up in 2026. there's a dedicated web page on this framework. If you would like to know more about this framework, you can go to the web page here. And there's also a very nice video animations, but I'm not going to show to you now in the interest of time. Apart from APEC, there's also some other related ODL developments. The ISO, the International Organizations for Standardizations, has developed the ISO 32122 to provide guidance on ODL for e-commerce transactions, including some basic principles of ODL, which are basically adopting many ACODA standards in that instruments. But during the developments of this ISO just published earlier this year, they have actually made reference to the APEC collaborative framework. So it's interesting. For APEC, we make reference to UNCITRAL, and then the ISO make reference to what we have done at the APEC. Yeah, that's how things are developing in this region. And I should also mention that UNTAC, the UN, the United Nations development on the trade and development, yes. Also developed a proposal on ODR platforms, and this initiative target on consumer disputes. The APEC one is limited to business. It does not cover consumer disputes for various reasons. And the UNTAC, they have proposal on ODR platform for consumer disputes. And just last year, they made declarations on the value of the ODR for addressing consumer disputes, and they also made a proposal for a global open source online dispute resolution platform. You can find more information on their website. Now, I will spend more time on the remaining part of my presentation on the IGIP on ODR, the Inclusive Global Legal Innovative Platform ODR. It's an initiative under the DOJ Project Office in collaboration with UNCITRAL. We gather experts from around the world to discuss some issues relating to online dispute resolutions. And the first meeting was held in 2021 to assess challenges and developments in ODR and discuss leveraging ODR platforms to resolve cross-border disputes. And we have so far held 4 meetings, and the 4th meeting was held in March 2025 to discuss a draft submissions from IGIP to the commissions. And we made the submissions in April this year, and it's available online. You can also see a screenshot here. And the commission endorsed continued collaborations with the IGIP on ODR. And as Judith mentions, that we will have the 5th expert meeting tomorrow, discussing some further possible work. And some experts of the IGIP on ODR are actually present at this conference, including Teresa, of course. Basically, the recent work we have done under the IGIP on ODR is, I would mention in particular the 3rd expert meeting in 2023. We identified 3 types of dispute resolution platforms. First type is the platform dedicated to providing ADL services entirely online. We have seen that there's some new service provider, they just provide ODL services. For example, in Hong Kong, we have the EBAM Center. They also have representative here today. And the second type of platform is sort of a consumer grievance mechanisms within larger platform for online transaction as a one-stop service like eBay, Alibaba, those platforms. And the 3rd type of the platforms is the platform for conventional arbitration and mediation service with a system for exchange of electronic record and communication between parties, and possibly with remote hearing facility, etc. Joanne has just mentioned the Hong Kong IAC is they provide this type of platforms. Yeah. Following the 3rd meetings, the Asian Academy of International Law, AAIL, assisted us in conducting a survey of some platform providers and prepare a report on the standards adopted across dispute resolution platforms. Basically, we identified 9 standards. They are accessibility, accountability, competence, confidentiality, equality, fairness, and impartiality, legality, security, transparency, etc. All these standards have actually also been identified by ICODA, the International Council for Online Dispute Resolutions, and we are discussing whether that further work is needed for these standards. And at the last meeting in March this year, we also further discussed these standards, and also whether we need additional standard like suitability, and we also consider the implication of AI, whether standard of fairness and impartiality should refer to preventing bias in AI power decision making, etc. But I will not go into the details until we may talk more about the AI. And also, there's presentations of our discussions at the UNCITRAL Commission in July this year. At the 58th Commission's, the sessions of UNCITRAL, it's noted that the suggestions to prepare harmonized standards to ensure the legitimacy of ODR processes, and the Commission requests the Secretariat to continue collaboration with IGIP on ODR for exploratory work on platform-based dispute resolutions. And a questionnaire has been circulated to states for further input. And the states have been asked to indicate some of their preference or views on whether UNCITRAL should undertake further work beyond the 2016 technical notes on ODR that I just mentioned, and which of the 3 types of platforms should be relevant for UNCITRAL further work, and which standards should be relevant for UNCITRAL to examine and develop. And tomorrow we will have our 5th expert meeting for IGIM and ODR, and we will further discuss these different types of platform, whether further work, which platform we should focus our work, and also the standard. So, as Judith said, if it's after the meeting tomorrow, I can tell you more, but currently we just follow some questions. Maybe we'll also invite your views and input. Of course, tomorrow we will have the roundtable at the morning, so if any of the judges or participants will have some input, we very much welcome your input. So that concludes my presentation. Thank you.
Thank you very much, James, for giving this very comprehensive overview, and also for reminding us how you can use UNCITRAL instruments. So whatever text is out there, you can use it as you think it's useful, as for your own purposes. So this is really what UNCITRAL is for. It's standards that are developed by everyone in the most possible, most inclusive manner, and then you may use the results as you see fit. And I think this is probably a very good example that showed how this happened in the case of the online disputes on the online technical notes. And in that frame, I have a question for you from the audience, and that is how Hong Kong's legal system and bilingual legal services provide a distinct, provide a distinct advantage for implementing the APEC ODR framework, especially for cross-border e-commerce.
Thank you. These are very good questions. As I've just mentioned, we have the event center in Hong Kong. That's one of the APEC listed ODR providers under the framework, and it's making good use of our bilingual legal system. We have both Chinese and English as official languages in Hong Kong. And as you know, in cross-border transactions or disputes, it often involves more than one languages. So our natural advantage is Chinese and English, but actually our ODR providers is also providing actually AI translations. So they can do all the UN languages for the parties. So when they have a case, they actually can use all these AI tools with the translations, etc., to help them to communicate and also resolve their disputes. And for Hong Kong, we are very active in the development of not only in the area of AI, but law tech in general. Our department has just this year has arranged or set up a expert group or advisory group on the development of law tech. So this is one of the areas that our department has been doing. So we very much support the development of technology in this area.
Thank you very much. And I got some more questions, but I will keep them for the very end, because you saw also whoever speaks now to dispute resolution today inadvertently touches upon AI. So maybe we should hear Teresa first before we have the rest of the questions. So Teresa, the floor is yours.
So good afternoon, ladies and gentlemen, authorities. Please let me first start by expressing my condolences and in a most festive note to the gratitude for the invitation and congratulations on the splendid organization by the host. So I'm going to talk about the use of AI in the context of arbitration. And in order to do that, the first thing that we have to do is to understand what is the phenomenon that we are trying to embrace. When we talk about artificial intelligence, we need to understand that it's a changing technology, there is a changing technological phenomenon. And that means that when we take a look to the three different stages that you can see on the screen, we are going to identify first different use cases in the application in arbitration proceeding, but also significantly different legal implications when we talk about AI that is predictive AI, when we are talking about large language models, so essentially generative AI or general used AI models, but we are at the moment realizing that the emergence of AI agent, agentic AI, is also impacting and permeating arbitration. So let's think about the type of uses that we can imagine, and we know already that they are in practice in arbitration. So it could be as simple as preparing for the arbitrator a timeline of the facts that are relevant. We could use them for the purpose of translation. We can use them for the purpose of preparing summaries of the practice of the evidence. But we can also use them for the purpose of preparing the first draft of the decision, or even produce and generate the final arbitral award, with or without subsequent arbitral or human review. And the legal implications are very different. And that is the reason why, in addition to all the different UNCITRAL text that has been already cited and has been already alluded, for example, the model law on electronic commerce, the model law on electronic signatures, the model law on identity or digital identity and trust services, all of them are relevant to the story that we are talking about, how the decision is adopted or more communicated. But when we think about agentic AI, the real question is who is making the decision, or to whom we are going to attribute this particular decision. And that is the reason why I wanted precisely to mention here the value of the UNCITRAL model law on automated contracting that we adopted at UNCITRAL Working Group 4 last year. And I had the enormous pleasure of being the delegate of the Kingdom of Spain during the discussion, but also the European Law Institute principle on automated decision-making and digital assistant. And why is that? Because one of the questions that we are going to raise in a minute is to which extent an automated decision-making in the context of an arbitration proceeding, for example, accepting or refusing a particular evidence, or even deciding partially or totally the final proceeding, could be indeed valid and enforceable. Of course, I know that the model law on automated contracting is about commercial transaction, but in a way, we are already devising and we are already laying the foundation for where we talk about automated decision-making in general. What we're going to do in the next part of my presentation is to summarize the principle that we have produced in the International Arbitration Center of Madrid, where I chair a group where we try to elaborate fundamental principle and recommendation for the use of AI in the context of arbitration. What I would like to do is to use this principle for the purpose of identifying the risk, identifying the challenges, and start proposing some of the solutions that we could implement at the level of UNCITRAL. And that led me, the last part of my presentation, to suggest where we have obstacles in the model law on international commercial arbitration, obstacles that should be alleviated or removed, and where we are, the possibilities that we have in order to foster the use of AI in international arbitration. So let me please give you an idea of these 10 principles that I'm going to group in 5 different problems. The first one is the use of AI in an arbitration proceeding permitted? And my answer is very positive. Yes, it is. Yes, it is, even if we don't have a specific legal recognition to that end. So if it's not forbidden, if it's not limited, for example, the AI regulation that is considering the use in arbitration as a high-risk AI system, but apart from that, we could say that is per se permitted. But because arbitration, as you know very well, is presided by the autonomy of the parties, could the party permit, limit, or even prohibit, and this is for me the most controversial aspect of this, to which extent they can't set condition for the use of AI in the context of the arbitration proceeding? Yes, they can, certainly. How and when? First, in the arbitration clause, no doubt. And I will give you an example later of when we can find an obstacle in the model law on commercial arbitration. Second, in the first procedural order, when agreeing together with the arbitrator or the arbitral tribunal how the proceeding is going to be conducted. They can set a specific condition. So this is the first problem. The second problem is a combination of the following principle that I'm going to split in different parts. So the second problem is, who is going to be the decider? Who is going to be the final ultimate decision maker? The arbitrator. So the next principle that, in my opinion, is decisive is the arbitrator, the arbitral tribunal, is responsible for making the decision in relation to this arbitration proceeding. Why is that so important? Because when we talk about AI agent, we're talking about a delegation. I know what that means, and I'm using that word intentionally. A delegation of certain decision-making functions to an AI agent. So who should be in control of that decision? The arbitrator. Let me show you that in a minute. Second, what that means, this responsibility? That means that the arbitrator is responsible for being duly informed, to better understand, and to be trained in a way that can manage hallucination risk, limitation established in the terms and conditions, potential risk of the use. This is the responsibility of the arbitrator. The next point is, what are the real risks of AI in arbitration proceeding? Essentially 3. The first, integrity. This is probably not as obvious as confidentiality, but in my opinion, extremely risky. Integrity means that you are using AI in a way that could be contaminating the fact and the evidence that you are using, that you are considering submitted by the party in the context of the arbitration proceeding. And this is a huge risk. Maybe because they are artificially generated by the AI system, or maybe because they are fed from the outside, from the environment, and therefore they are not part of the documents submitted by the parties. Definitely confidentiality, and definitely traceability. And why definitely traceability? Because for me, what is the next fundamental point, the pivotal point in the arbitration proceeding? If we assume, and this is something that the model law opened the door to consider that differently, but if we assume that any arbitral award has to be reasoned, has to be a reasoned decision, if the system is not traceable enough, maybe the arbitrator who is relying on that decision without any possibility to be in control of the decision and therefore impossible or unable to provide the reason, we may have there a key point to address when we are talking about the use of AI. Next point, and my last point before framing this into the model law on international commercial arbitration. For me, one of the most controversial points here is to which extent the arbitrator has a duty to disclose. Has a duty to disclose by law, or a duty to disclose because the parties ask the arbitrator to disclose the use of AI. Why is controversial? For 3 reasons. First, when? When I have to disclose? At the very beginning? Anytime? I need to renew my disclosure anytime that I use different AI models in the market in order to do different things? What do I have to disclose? That I am using AI, or that I am using this particular version of this solution for that purpose? Do I have to disclose the prompt that I am using, for example? Third, what are going to be the consequences of that? What happens if I do not disclose? Is that a ground for challenge? Is that a ground for setting aside? Is that a ground for not recognizing or enforcing the arbitral award? So, what are the implications of this principle in the current UNCITRAL model law on arbitration? 3 different implications. Let me just summarize in the couple of minutes left that I have. First, is that possible? Is possible to use AI? I would say yes, in the current wording of the model law. But please, take a look at Article 2, 11, or 12. When we talk about Article 2 and 11 together, we see that it's talking about arbitrators who are persons. So can we imagine that there is a full delegation to an AI agent of the decision? Probably not at the current wording. Second, Article 12 is referring to circumstances likely to impair the independence. Could the use of AI be precisely that circumstances to be disclosed because they are compromising potentially the independence and impartiality of the arbitrator? Third, could be indeed one of the conditions that raise doubt about that impartiality. Second group of issues. As Judith mentioned before, could the use of AI create an equal treatment of the parties? For example, because you are interacting with parties with a chatbot, and that creates a certain disadvantage in terms of technology accessibility. Second, could we consider that an AI could be an expert? Could we consider that the arbitrator think that this expert system is precisely one of the experts that can be nominated according to Article 26? Final group of conditions or problems to discuss. When it's talking about the decision making, so I'm talking about agentic AI essentially. So Article 29 refers to the decision adopted by the majority of arbitrators and signed by the arbitrator. Could we delegate that particular decision to an AI agent? Is meeting this requirement? Second, Article 33, a reason word. The award shall state the reason upon which. If the arbitrator is relying too much, probably negligently, on AI in a way that is unable to explain why this particular decision has been adopted, definitely we could have a problem of infringement of Article 31, unless the parties has accepted a non-reason award. Final point, Article 34 and 36, setting aside. Do we already have, and Judith, I know that you are particularly interested in this point, do we already have in the model law causes or conditions that could be used in order to set aside an arbitral award, or as a ground for challenge or not recognizing, because the arbitrator has used AI? 3 possibilities. The first one, that the parties has prohibited the use or had limited the use in the clause. Second possibility, that the composition of the tribunal is not the one agreed by the parties, because an AI becomes a new aligned outsider in the tribunal. Third, public policy, to the extent that a particular jurisdiction has decided to limit or even to prohibit the use in dispute resolution of AI. Thank you very much, and happy to discuss further.
Thank you very much. And as you have seen, we needed much more time to really discuss this thoroughly. What, maybe as a very first remark, I have a bit of a problem with terminology, and this refers to the term decision. And if a decision is a decision and not probability, and this is how I understood AI, that AI is somehow predicting what is a likely outcome, then we have no decision, and then we have no application of the New York Convention. So I think the term decision is a crucial one in this context. Can AI, technically speaking, can you really speak of a decision, or is it more probability, hence no application of the New York Convention?
Thank you, Judith. It's a key point, and that was the reason why I started with this three-level evolution of AI. Definitely, predictive AI is essentially based on this probability, in this idea of having an option that is more likely, more probable for the purpose, for example, of identifying what is going to be or should be the decision in a particular case, taking into account previous case law and the facts submitted by the parties. But when we think and we talk about agentic AI, we are indeed assuming that there is a delegation of complex tasks that include decision-making. So that include decisions that are going to have legal effect. And that is indeed the spirit of the model law on automated contracting. Because in the model law on automated contracting, we are assuming that the AI agent, what we call the automated system, is deciding, for example, deciding to submit an offer, accept an offer, performed, negotiate, renegotiate, terminate. This is not essentially probability. It's indeed an action that has the meaning of a legal decision. That is why, if we really opened the model law on arbitration, if we went to open to the use of AI, we need to open taking into account the implication of agentic AI. Not only generative AI, that is definitely challenging, but essentially the idea of AI agent. This is at the horizon. It's already permeating most of the economic and social activities, and definitely is going to impact on the idea of justice and the idea of who is indeed settling that particular dispute.
So I'm a bit surprised because we have no question on AI yet. So under these circumstances, I would come back to you, but invite you to, I think you give us so much food for thought that we need to digest a bit, as we are not AI, so we need a bit more time to react. But I would come back to you, Joanna, now, because I have a number of questions for you. So how is the Hong Kong International Arbitration Center facilitating the use of its remote hearing protocols and online dispute resolution capabilities for disputes arising from cross-boundary digital trade? And this thing is jumping. How is, yeah, that was the question I was just reading. Okay, the other question disappeared. So maybe I give this question to you first, and then we see if the other questions reappear.
Sure. For HKIAC, we have a dedicated IT support team. So whenever parties, if they have hearings at HKIAC and they intend to do part of it virtually, and they want some guidance as to best practice or just how to set up or just a rough idea of what the process is like, then we are able to really be there and answer questions. And in some cases, if they need facilities from us, we are able to host virtual hearings for parties as well. So that's the short answer.
Thank you very much. I was hoping for a longer answer till I tried to read what Queenie is trying to tell me. The time is up. So that was not orchestrated by AI. That was typical human. So you see we are not there yet. But we would really invite you, if you have some comments, if you have whatever idea or where you see the need that UNCITRAL could usefully provide some help in harmonizing certain approaches, please let us know. And I know that the judiciary is handling exactly the very same questions that we are handling. The setting is a bit different, but in principle, we are all confronted with the very same questions. So I'm very happy if we could together try to find some adequate responses to these challenges to come. And I do hope I saw this handshake between the machine and the human being in front at the logo of the conference somehow. And I think this is a very telling logo. I hope this is the future that we may be able to coexist, even if AI is taking decisions on our behalf. Thank you very much.
Thank you again. Can I invite everyone to remain in your seats and just take a quick snap before I have everyone take their seats? Thank you very much for that discussion. I wish we had more time, but nonetheless, we are just as grateful. Thank you very much to all of our panelists, and thank you, Ms. Knieper, for being our moderator as well. Everyone, please be seated. Thank you. Now, before we move on to our closing session, may we invite all of you to take a moment to fill in the feedback form by scanning the QR code that is on the screen. Your feedback is invaluable in helping us improve our future programs. Thank you once again for all your support and active participation. However, before we conclude the conference for today, can I please invite the Honorable Dr. Chen Kuo-kwan, SPSJP, Deputy Secretary for Justice of the Government of the Hong Kong Special Administrative Region, People's Republic of China, for the closing remarks. Dr. Zhang, please.
Your Excellencies, distinguished guests, ladies and gentlemen, the conclusion of today's Judicial Conference, jointly organized by UNCITRAL and the Hong Kong International Legal Talents Training Academy of the Department of Justice of the Hong Kong Special Administrative Region Government, marks a major milestone in advancing global legal cooperation and the exchange of expertise in the realm of digitalization of trade. The insightful discussion throughout the day have offered meaningful perspective and set the stage for continuous engagement among members of the judiciary, government officers, legal specialists, petitioners, and stakeholders. These positive outcomes will foster continued professional interaction and constructive dialogues in the times ahead. Centered on the theme building towards end-to-end digitalization, today's sessions have demonstrated our collective dedication to facilitating and harmonizing the seamless digitalization of trade transactions. Our first panel today explore the intersection between virtual assets and existing commercial and financial legal frameworks, with a particular focus on how virtual assets intersect with existing legal systems. The discussion highlights evolving legislative frameworks from different jurisdictions designed to address the unique characteristics and challenges posed by these assets. Several legal instruments, including the UNCITRAL Unidraft Model Law on Warehouse Receipt and key initiative of the Hague Conference on Private International Law supporting digitalization were explored, with the aim to ensure that digital assets are governed by predictable and interoperable conflict of rules worldwide. The panel devoted particular attention to enforcement aspects, emphasizing how court and regulatory bodies are adapting to the complexities posed by digital asset transactions and related disputes. Financial implications also formed an important part of the dialogue, highlighting the increasing prominence of virtual assets in the broader financial ecosystem. These legislative frameworks, enforcement, and financial initiatives signify a concerted move towards a harmonized, innovation-friendly legal environment that supports the seamless digitalization of trade and finance, ensuring these emerging assets are effectively incorporated into the global legal and economic landscape. Panel 2 provides a detailed overview of the UNCITRAL model law on electronic transferable records, MONITOR, highlighting its crucial role in enabling the transition to paperless trade. The MONITOR has garnered attention across the region, where an increasing number of jurisdictions, including Hong Kong, are actively exploring legislative amendments to adopt the UNCITRAL model law. This panel discusses how these legislative advancements support the border trade digitalization agenda, particularly benefiting micro, small, and medium-sized enterprises by simplifying cross-border transactions and reducing reliance on cumbersome physical documentation. The panel also examined key provisions of the MONITOR and implementation challenges, looking its interaction with foundational UNCITRAL instruments such as the model law or electronic commerce to create a cohesive legal framework for electronic transactions. Additionally, the emerging case law interpreting UNCITRAL text was reviewed, illustrating how judicial approaches increasingly integrate both legal reasoning and technological understanding. This evolving jurisprudence reflects a judicial readiness to oversee complex digital transactions, balancing legal certainty with technological innovation. As outlined in the Chief Executive's policy address this year, legislative proposal will be introduced in 2026 in Hong Kong to provide legal basic for the digitalization of business-to-business trade documents with reference to MONITOR and experience from other common law jurisdictions. Hong Kong, as an international trade center and an international innovation and technology center, is developing a more streamlined paperless trading environment. This advancement will enhance the validity of digital trade flows, mitigate risk, and accelerate cross-border transactions. Hong Kong's dedication to embracing the MONITOR highlights our determination to remain at the forefront of global trade innovation and to support business in seizing new opportunities in the digital age. Panel 3 examines the recently approved draft United Nations Convention on Negotiable Cargo Documents, which has been recommended for adoption by the United Nations General Assembly. This groundbreaking convention fills a crucial legal gap in international trade by creating a harmonized legal framework for negotiable documents of title applicable across all modes of transport, air, road, rail, and sea, regardless of the multimodal journey involved. This panel provided an overview of how this harmonized framework addressed inconsistencies and legal voids in various domestic laws, fostering greater certainty and uniformity in the recognition and transfer of negotiable cargo documents. This panel also discussed how the draft convention interacts with the existing international treaties, ensuring its complements rather than conflicts with current legal regimes. A significant portion of the dialogue focuses on the practical opportunities and challenges this draft convention presents for their domestic implementation. Panelists discuss pilot projects testing the draft convention's provisions in real-world scenarios, highlighting potential legal issues such as transport operator liability, interoperability of electronic negotiable documents, and the need for clear recognitions on electronic document issuance and transfer. The draft convention stands to transform and modernize international trade by unlocking trade finance, enhancing supply chain efficiency, and enabling seamless door-to-door logistics. It represents a landmark step forward, fully digitized, integrated global trade, supported by robust, harmonized legal foundations. Our final panel today focuses on the ongoing exploratory work under antitrust dispute resolution in the Digital Economy Project, which addresses the impact of emerging technologies on dispute resolution mechanisms. This includes an in-depth examination of how AI and law tech are reshaping the landscape of dispute resolution. This panel explored the latest capabilities of AI technology in supporting arbitration, mediation, and other dispute resolution processes, highlighting both its transformative potential and current technical limitations. The discussion emphasized how AI can augment rather than replace human judgment, enhancing case management, predicting outcomes, and improving access to justice, while recognizing that responsible use requires robust safeguards. A key focus was the development of procedural guidelines for remote hearings in arbitration and mediation, an area of growing importance given the increased reliance on digital platforms. Panelists are evaluated platform-based dispute resolution mechanisms which leverage technology to facilitate cost-effective and timely resolution of disputes, particularly in cross-border and e-commerce contexts. The responsible deployment of AI technology for dispute resolution was extensively discussed, including how existing regulatory regimes are adapting to monitor and mitigate risks such as data security and ethical concerns. This panel serves a vital starting point, opening the door for the insightful discussions of the Judicial Roundtable tomorrow. As well as Day 5 of the Hong Kong Legal Week under the theme, The AI Era, Shaping the Legal Landscape in the 21st Century. It sets the stage for a more in-depth exploration of how AI and related technologies will continue to transform the legal profession, dispute resolution process, and the broader justice ecosystem in the years to come. Before closing, I would like to commend the Hong Kong International Legal Talent Training Academy for their collaboration with UNCITRAL since its launch in last November during the Hong Kong Legal Week 2024. The Academy has organized numerous training programs in Hong Kong, the Chinese mainland, and abroad, covering a diverse range of topics and targeting a wide spectrum of participants. Through collaboration with international organizations and government bodies, the Academy plays a vital role in fostering the exchange of international legal talents capacity through capacity-building programs, strengthening Hong Kong's strategic position as an international legal and dispute resolution services center in the Asia-Pacific region, establishing Hong Kong as a capacity-building hub, and actively participating in the next decade of the Belt and Road Initiative, contributing to our country's efforts to promote the construction of the rule of law. I wish to express my gratitude to UNCITRAL for the support to the Academy so far and the ongoing engagement and continued collaboration with the Academy in the years to come. Ladies and gentlemen, as it comes to the conclusion of the Judicial Conference of the 6th UNCITRAL Asia-Pacific Judicial Summit 2025, we must thank colleagues of UNCITRAL, our colleagues at the Department of Justice, and all the distinguished judges, speakers, and moderators and participants who have joined us from across the globe. While the Judicial Conference wraps up, and so, as the first day of the Hong Kong Legal Week 2025, there is a diverse range of events that we have arranged for the remainder of this week. To our esteemed judges, we will see you at the Judicial Roundtable tomorrow morning for continued dialogue and meaningful exchanges. For all other participants, we also anticipate your presence at the third Legal Forum on Interconnectivity and Development tomorrow afternoon, as well as many other enriching sessions that await us for this week. Thank you once again for your participation and contribution today. Thank you.
Thank you, Dr. John. And please be seated. Appreciate it. Honorable judges, distinguished guests, ladies and gentlemen, the Judicial Conference of 6th UNCITRAL Asia-Pacific Judicial Summit 2025 has come to an end. On behalf of UNCITRAL, the Hong Kong International Legal Tenants Training Academy of the Department of Justice of the Hong Kong Special Administrative Region, I would like to express our sincere gratitude to all of our speakers and moderators for their insights as well as their excellent presentations. We also extend special thanks to every guest who participated today, both in person and also online. Please note, before you leave, we would like to once again invite you all to complete the feedback form by scanning the QR code that is on the screen. For those of you who has been using the SI device and earphones, please leave the devices on the table or return them to the counter outside the hall. For in-person participants who require CPD points or ALE points, please present your QR code outside the conference hall to sign out and confirm your attendance record. Thank you once again for joining us in person and online. We'll see you at other events at Hong Kong Legal Week 2025. My name is MC Melody. Thank you for being with us.